Also, a request by mother for parenting time. I know the first thing that we start out with here is that Mr. Sherlin says that there's a counselor involved in this case that was not agreed to, which would be a joint legal decision. Is that basically it, Mr. Sherlin?
It's one of the issues, yes, Your Honor.
Ms. Wagner, was that an agreed upon counselor?
Your Honor, my client sent him a text message indicating that she had planned to start the child with counseling. He read that text message. A month later, he then requested the contact information for the counselor so that he could be involved with the process. So I would not dispute the fact that there was no written consent for the request. But I do think, just for purposes of speeding things up, it would appear that the parties are in agreement that counseling is appropriate. So I think she has no problem with whatever counselor that they want to agree upon. And I think they can probably handle that themselves. And if not, Mr. Sherlin and I are more than capable of assisting in selecting a therapist. That's funny, because I wrote down here, attorneys can agree on a counselor without knowing that. Was that just a lucky guess, Mr. Sherlin?
It was wisdom on your part, Your Honor.
I'm sorry, I kind of not real clear.
Your wisdom in anticipating that we could do that.
Well, I like to hear you say my wisdom, so I'll ask you a couple more times. All right, so where are we at? That the counseling matter, you're saying change legal custody, why? Your Honor, as my motion lays out, the judgment of divorce has a provision in it that prohibits the plaintiff from consuming alcohol during his parenting time. That's clearly not a standard provision in judgments of divorce, and it's only applicable to him, not to her. There was a concern throughout the marriage of his use of alcohol and having a problem with it. When he drinks, he gets rather mean and aggressive. He has resumed drinking during his parenting time. That has been disclosed both by him in a conversation with my client in which he promised to get sober and that her significant other was present for, as well as disclosed by the child to his mother and to a therapist that his dad is drinking during his parenting time. So there are concerns in regard to his ability to make solid decisions if he's has been examples of him being unable, the two of them working together and not being able to make those decisions. Well, he, without having any communication with her, went ahead and revoked the child's therapist without finding a different therapist or someone to take that place. And given that the child has shown some significant anxiety over the summer, I would consider that a basis. All right, Mr. Sherlin.
You mean the weaponized therapist who wrote the letter that's not on letterhead?
I understand. I'd kind of discount that because there's no letterhead, there's no signature, there's no date, there's no nothing. Right. Quite frankly, written by anybody. I'm not. And the parties are going to work out and agree to a counselor. So that kind of takes that issue away. The biggest thing that I have, and I don't believe that there's Vadvarka for change of legal custody. They might have had a blip in the road, and if it continues, it definitely will. I mean, I'm not going to have them disagree on all kinds of stuff or him not answering that kind of stuff. The bigger issue becomes, Mr. Sherlin, is consuming alcohol. I don't know. Obviously, he's going to deny it. She's going to say she's heard it from the counselors and all that kind of stuff. It is a provision in the judgment, which is unusual. We don't put them in unless there is an issue regarding substance use. I think the better issue or the better way to handle this may be some type of a breath test that he could perform both at the time he picks up the kids and at a couple periodic times while he has them, maybe do that for a couple months. And then once that is, if it proves to be fine, then I'd take that off. That's what I'm looking at.
Well, Your Honor, in our response, we said that if the defendant wants to buy 2 breathalyzers, both parties can breathalyze at the start of it.
I'm not making this a mutual. There's no reason to make it mutual, Mr. Sherlin. There's nothing to indicate that mother is. And I'm looking for some solution that he can provide breath tests before at the time he picks up the kids, and that I'm not going to change his parenting time if he's willing to do that for 2-3 months, whatever, and things come back clean, kind of no harm, no foul. But
here's the problem though, Your Honor, and he's willing to do that. The problem is the helicopter aspect of the defendant's parenting. So she purchased a watch for the child, and
I understand that too, and we're not going to get into
her watching every minute and having to be contacted every minute. He's got to have his parenting time. You got to have your parenting time. I don't know that this kid is any significant danger with the father. If we can get some breath tests, that's what I'm looking for right now. And if he does fail in any of those, then it's going to be altogether different, completely different.
Your Honor, my client, he just wants a sunset on this, right? Oh. He wants a sunset so that once he demonstrates that there aren't these concerns that, we can put this to rest.
All right. I give him 3 months of good breath tests when he has the kids. And then I'm not going to prohibit mom from having any contact. For Christ's sake, when are these people going to figure out that I'm not going to parent their kid? They need to get along, ma'am. When he has the child, yeah, you should have some contact with him, but as he works through counseling and stuff like this, the two of you have got to parent this child, not me. And you have legitimate concerns. I'll at least enough that I want to have him do a breath test. And between Mr. Sherlin and Miss Wagner, you can figure out how it is. It'll be done at the time he gets the child. If he has them for a weekend, it'll be done on maybe twice a day on Saturday and in the morning and in the evening, and again in the morning on Sunday. And that's what we're going to work with. I'm not going to prohibit her from having any contact with the child. This child is only 8 years old, but ma'am, you got to trust that the child is not going to be eaten alive while he's over at dad's. I assume that the dad does not want him injured any more than anything else. And as long as he's not drinking, he's probably an appropriate parent. But
what we really need, Your Honor, is her not saying, is your dad drinking? Is he being mean to you? That's
okay. And tell me how I'm going to enforce that unless I sit over to her house.
You're not going to, but I will bring it back to your attention if it happens.
Well, I'm sure you will. That's fine. I'm going to be here 2 weeks from now and 2 weeks from now and 2 weeks later.
I just think some instruction from the court that you can't do that type of sabotage would be helpful.
Well, then I'm going to be giving it to everybody today. You can't try and sabotage the relationship, man, nor can you. Sir, and if you are drinking and you did admit to it, you need to step up and do something about it instead of just denying it. Mom has every reason to be concerned, and there obviously was drinking in the past, and she has a right to be concerned. And if you don't acknowledge that, then you have lost all credibility. You need to do what's appropriate, ma'am. You need to do what's appropriate. Yeah, I don't want you questioning the kid. Is your dad drinking? If your dad drinking, you're going to have some tests from it and things like that. You're going to get a chance to go to a counselor where the kid can deal with things. What do you want me to be there for the exchanges and stuff too?
No.
That's basically, well, I don't know if he's doing wrong and I don't know if she's doing wrong. Let's just figure this stuff out. He'll do breath tests. You can, I don't care what app and stuff like that. There are some apps out there I think you can do. If it's a breathalyzer or whatever, he's got to be able to inform her of his test at the time of the test. I believe both of you have knowledge on how to do that, don't you?
I think Mr. Sherlin and I can work together to make sure an appropriate device is selected.
And if there's a cost associated with it, can we split that cost, Your Honor?
It's going to be his cost for right now.
If he's clean at the end of it and hasn't had any.
If he's cleaning at the end of it and has done everything, you can move for some portion to be hers, but it's not even, I'm not going to, I have enough evidence that I'm concerned that there is drinking. All right. And so I'm going to make it his responsibility. You can reserve it if you want, but I'm not going to give you much if it's clean, because I'm hoping that it's going to be clean. And even if he is drinking, maybe he'll give it up anyhow.
And then do we need a separate motion on all the makeup parenting time?
Do we what?
Do we need a separate motion on the makeup parenting time? There's been a bunch of parenting time withheld.
Yeah, you're probably going to have to, unless you want to talk to Miss Wagner and agree to something. Otherwise, you're going to have to file a motion because she's not prepared to deal with that today.
I understand it. I didn't put it before the court, and I hope we can agree upon that. It sure would make sense if the court's looking for the parties to find a way to cooperate. There's no denial. The denial of there's no denying that the parenting time was withheld. There's an excuse, but
Yes, and it might be a valid excuse. I don't know. You guys have to deal with that. And my ruling is going to be the two of you are going to agree on a counselor, and I need you to agree upon that within a week. All right. Two attorneys who I believe can do that. All right.
Thank you, Your Honor.
Second.
And I can go ahead and prepare the order. Sorry.
Second is the alcohol test. It'll be for 3 months once it gets hooked up. All right. And the two of you will agree on what is an appropriate test. It'll be his cost. Other than that, I'm not going to change any parenting time or anything. At this time, if you want to file for something, Mr. Sherlin, you can file whenever you want.
yeah, sure. You said start a parenting time on the weekend, then 2 times on Saturday, 1 time on Sunday morning.
At least 1 time on Sunday, in the morning, something like that.
Okay.
Because the child goes back Sunday after evening, doesn't he?
He has midweek overnights too, Your Honor.
Pardon me?
He has midweek overnights.
Midweek overnight, then I'm going to require a test when he picks up the child. What are his midweek overnights?
He has 1 overnight on 1 week and 2 overnights on the next week. So can we handle the 2 overnights like the weekend?
Yes.
And then the 1 overnight would just be a shortened version of, so
Yes.
1 in the evening, 1 in the morning?
Yes.
Okay, sounds good. Thanks for the clarity.
Ms. Wagner, anything further?
No, all set. Thank you, Your Honor.
Thank you. I'll look forward to the order. Thank
Okay.
you.
Thank you.
There he is. Well, welcome. I mean, it was nice looking at you for a while, and your client who's wearing a Michigan outfit, which I'm sure grinds you, but
I apologize for my client wearing such hideous apparel to a very respectful hearing.
is that Mr. Donaldson?
It is, Your Honor.
Mr. Donaldson, nice choice.
Thank you. Go blue.
Yes, sir.
No, we don't want a stop video.
Mr. Engman,
Sure.
Yes, sir.
I can hear you, but I can't see you.
Yeah, I'm working on that. Right, my secretary's working on the other
The
side of my
dark
desk in that part. You got that part up. It says it.
I can see the stars. Are you? We'll be here all day, Tracy, doing these.
Oh, hang on, sure.
I got a late start because I forgot my glasses at home and had to go back and get them.
There it is.
V. Donaldson, both parties are present via Zoom, and they are represented by their respective attorneys. Mr. Engman for the plaintiff, Ms. Donaldson. Mr. Cox is here for Mr. Donaldson. This is the plaintiff's motion to object to an ex parte to sell the house, which was granted by Judge, I believe, I'm pretty sure it was granted by Judge Hillary. If I'm not correct. Isn't that correct?
That is correct.
All right. What is it says straight in the judgment, it's got to be sold immediately. I don't know what else I'm supposed to do.
Well, that's that
Be
part.
listed
There's
for
a
immediate
whole lot of
sale.
other stuff in
What?
this case. There's a whole lot of other things in this case.
I'm reading the judgment. The
Yeah, I
judgment
know.
has to be
Right.
immediately listed. Why would I not make it immediately listed? Judge has given the order because he read the judgment, has to be immediately listed. Therefore, has to be immediately listed, and I'm not gonna get rid of the ex parte. Why? I mean, what else is there?
Well, there is some major things that have been destroyed in the house that would materially increase the value of the house if they would be done.
Part of the problem
My
is,
client worked with a realtor trying to get these things done.
part of the problem is you said the realtor went through the house in July and the judgment didn't get signed till the end of August. Why wouldn't that have been dealt with in there if this was such an important issue?
The judgment got signed in August, but we had already been a trial in June.
Yeah,
We had a
and
trial.
you had a realtor, you said they're in July, and you should have been dealing with this because there was nothing in the judgment. And I can't go changing judgments for no reason. And that is, there is an immediate sale of the house. You guys are both probably going to lose out on significant amount of money because of that, maybe. And if you two want to work together, that's fine. But there is nothing that Judge Hillary did that would be against what the order says.
We're not disputing them. We're not disputing the order. The ex parte is allowing him to sell it without me.
Yes,
When
because
I've
you
been-
haven't done anything to it.
I'm the only one that has actually done something to get the house sold, Your Honor.
Is it listed for sale?
It is not listed for
Then
sale. because
Mr. Donaldson can list it because you won't list it. It's been
It's
since
not, it's up
August.
to me to make the determination to list it. I have tried numerous times to talk with Mr. Donaldson. Mr. Donaldson said that he was going to work on those things. We have communicated, and he's stating in his ex parte that I have not done any of these things, and that is not true. I have taken the proper steps to sell the home. I've brought the house up current. I've paid the back mortgage when the mortgage was not paid for 6 months. I've taken care of those things, have been all a part of the process that Mr. Donaldson has been deceiving and not honest about his proceedings in the matter. He has failed to communicate with me in reference to selling of the home. I'm ready and prepared to sell the home. I don't want it to be done without me because I want to make sure that we're doing the things that we need to do, like I have
All right,
been.
Mr. Cox, what's your response?
Your Honor, Judge Hillary didn't appreciate, and I'm going to say respectfully, the plaintiff's loose relationship with the truth. And that's what happened at trial. She said a lot of things she couldn't deliver on, Your Honor, and we're back with the same issues. She wants to delay the sale. And I asked my client, I said, can you really tell me what is at the root of this realtor issue? And I'm going to tell you, Your Honor, my client says that she's upset because this particular realtor is not African-American. I don't care what nationality the person is. Your Honor, we need to get this house sold. And I would ask the court, please do not set it. Please, if I could talk uninterrupted.
Ma'am, he did not interrupt you and you will not interrupt him.
I apologize.
No. All right, Mr. Cox.
Thank you, Your Honor. Your Honor, we're asking the court to leave the ex parte order in place. My client is working with a neutral realtor that he never met before. I did refer the realtor to him. But in any event, that realtor is already working on the home. She can get it listed. We can get this thing sold. We've got to get these people out of financial distress. And this has dragged on far too long. And that's why I had to file the ex parte.
Is he going to list it?
As soon as we find out what happens today.
All right. All right.
Can we speak to that?
Your attorney can speak to it briefly, but I see nothing that says it's not supposed to be immediately listed and that it has not. As a result, Judge Hillary, who had the trial and stuff like that, agreed to make him the one to list it because you have not.
That is not true, Your Honor.
Well, it is true. It has not been listed. It has not been listed. It has not been listed, and it's been since August. Okay, August, September, October. We're 2 months out, and it has not been listed, and you have not done it. End of story.
The defendant is the reason that the house has not been listed. After he finally met with the realtor that he just brought in August. He has been out of town every other weekend. I have asked him, how are we going to work together? I sat down and was there when the realtor came, and I also talked with the realtor. Mr. Donaldson has not been willing to communicate and cooperate in the selling of the home.
I can understand. You guys are getting a divorce, therefore he probably doesn't want to communicate much.
We live in the same home, though.
For
So
sale,
unfortunately,
and it
we're
to be
adults.
done. As a result, I'm going to leave the ex parte in order. If Mr. Cox and Mr. Engman want to work together somehow to do this, that's fine, but I'm leaving it there. Next issue.
He's lied about all of this.
Next issue is our motion to an objection to the entry of that was that one. Hang on. Next one is we had a motion to enforce and amend the judgment of divorce. Okay. This is somewhat more serious.
You're going to have to do some kind of fraud or something in this.
Yeah, he didn't tell us about getting us a mortgage for $57,000. He didn't tell us about getting a 401k loan. That's $97,000 that he didn't disclose. We didn't get the paperwork to finalize the divorce until after all the paperwork was done. We want him to tell us where the $97,000 went. That's part of the assets of the marriage.
No.
Mr. Cox, you may respond.
Thank you, Your Honor. Your Honor, this is so far to left field, but I think what it does is a couple of things. First of all, their motion is asking to retry things that judge already heard testimony on. Secondly, this whole idea that the plaintiff was not aware of the 401k loan is nonsense, because once again, unfortunately, you've heard this before, these parties have had their house going hawk. and the plaintiff knew about it. Nobody did. There was no failure to disclose anything. And the ironic thing is that they're trying to put some sort of nefarious spin on his 401k. What happened was with his 401k, Your Honor, is he had a premarital portion, and we weren't sure how much it was. It wasn't a substantial amount, but we couldn't determine what the premarital portion was. He might have worked maybe, let's just say, a year or two before they got married. We couldn't find the darn thing, so we just said to heck with it. Just divide the whole thing. I mean, who cares? It's an extra year or two. Nobody cares. So that resulted in favor to the plaintiff, and she's now here trying to tell you that there's something nefarious about that. We just gave her, a bonus on the 401k. So, but I think the more important point for the court, Your Honor, is not only is this a rehash of the issues that Judge Hillary has already decided, it is now some sort of half-baked idea that, yes, as the court said, we've committed some sort of fraud. And I believe that they would have to establish that. And I don't think there's any way they can, because it just didn't happen.
You're gonna have to establish something more than just, I don't like what the numbers are. Were there interrogatories that were exchanged between, or depositions? And did Mr. Donaldson, you found that, he lied on him or something? Because otherwise, I don't see anything here.
Well, everybody disclosed everything.
For a period of time.
Again, it's sour grapes about the judgment.
Okay, we'll let him talk first. We tried for a period of time to get that information, but the defendant just simply couldn't get it to us. Then we find out after all the papers are signed that there's $57,000 mortgage in there. And then we find out that he took another $40,000 out of his 401k. Now, there's nothing about how much he had before or after marriage. It's not been disclosed. Okay, that's $97,000 out of the marital assets, Your Honor. And we need an evidentiary hearing to prove he can explain exactly how this happened.
You tried the case in front of Judge Hillary.
That's correct.
Was not,
but that information was not available.
Did you ask? Did you send interrogatories to say what are all the?
We had asked him to exchange information. We couldn't get copies of his 401k.
You got to the point where there was a trial, and did you ask there saying, hey, we don't have information, so we can't proceed?
Correct.
Well,
because Judge Hillary dealt with that already.
No, Judge Hillary gave them 2 weeks to produce that information after the June 5th trial. They did not produce the information until August. When we finally got the information, that is when we were able to see that there was a $40,000 loan taken out on out of his 401k within the same month that he took the second mortgage out. And coincidentally, that happened to be the same month that I moved out of the marital home temporarily for 6 months. And that's when he took out both of these loans within 30 days. And we do have proof and evidence to show that. In addition, we also have proof. He says that he took the $40,000 loan out to pay the mortgage. The mortgage was not paid. There was a back payment on the mortgage.
When did he say he took that $40,000 out to pay the back mortgage? When did he say he took the $40,000 out to pay the back mortgage? He
never disclosed it. It was discovered when we finally got the 401 paperwork to get to finally get the
and that's when he told you he took it out for the mortgage?
No.
That's what he put in the court documents. That's what his response says, that he took the $40,000 out to pay the mortgage. The mortgage was not $40,000.
Well, then you knew about it.
No,
this is his
only after
the documents that he just submitted.
You're going to have to plead something more along willful type of fraud or something like that. Otherwise, I'm not going to. I'm going to deny the motion. The only thing that is valid in this is he owes her, in paragraph 24, he owes her for half of the car payment, as my understanding, payment for one half of the car. He needs to pay that now.
What about the second mortgage? Am I going to be responsible to pay half of a second mortgage that I didn't do any? I didn't take any. I wasn't even in the home.
I have no idea what she's talking about. I really don't. Again, these issues were dealt with at trial, and she's obviously just unhappy about the judgment. And that's our
no, sir. No, sir.
We deny your motion regarding that. I am going to grant that when is he going to pay for one? It says right in paragraph 24. Pay for
defend me?
That.
Well, Your Honor, we thought we could get that out of the proceeds of sale of the house, which obviously we've dealt with that issue. So Mr. Donaldson, the referee's asking when can you pay her half of that car?
I got to find out how much it is. And then it won't be able to get paid until the house is sold because I don't have money like that.
We're not going to make no money off that house. We're not going to make money off that house.
Get the amount to him so that he at least knows how much it is.
$1,000 that he took out
Yeah.
for the mortgage.
And
you.
how
Where is
I'm
it?
responsible to pay
You be
half
quiet,
of a
let me
mortgage.
talk.
If Mr. Engman wants me to let me know what that number is, I will certainly work with him on that, Your Honor.
Thank you.
All right.
Other than that, I'm denying your request.
Thank you, Your Honor.
Thank you. We're adjourned.
You're not even gonna defend.
Johnson versus Lee. This is a request from the prosecutor's office through Ms. Brower for a judgment of support, indicating that I believe there are two kids. As I understand it, Mr. Lee has employer wages and mother has been imputed to $17 an hour times 35 hours. Ms. Brower, is there anything you would like to say?
I would, Your Honor. So on October 3rd, 2023, there was a pre-hearing conference which took place by phone. The court has correctly indicated the incomes that I used for the parties. I did impute mother income and I used the father's actual income. So at the pre-hearing conference, he stated that he already pays child support for the child, in this case, Chief. I explained to him that current child support for that child is not charging. I found that in 2013, he was ordered to pay child support for Chief to the plaintiff's mother. And not only was he ordered to pay it for Chief, he was ordered to pay it for the party's other child too, Eris. But I explained to him that current child support is not currently charging for that minor child, and that it ended on May 9th, 2021. I stated that he may have arrears that he still owes the plaintiff's mother for those children, but nothing current is charging. I explained that to him emphatically, but he wanted to continue to argue and to not listen. And it got to the point that I had to terminate the phone call. He subsequently talked to Michelle Smith-Lowe, who explained to him the exact same thing multiple times. And she further noted that he seemed aggressive. And he also felt that that our office was treating him as like a criminal. This is not a criminal proceeding. We're simply trying to collect child support for the two children. So I just wanted to put that on the record to be clear that no current child support is charging for the same two children that are on this case and that 2013 case. For these reasons, and the court has already correctly stated the party's incomes, I'm asking that the court enter the proposed judgment as well as the UCSO.
So the grandmother or whatever who was collecting it no longer obviously has the children, and we're just dealing now with the mother and the father.
That is correct, Your Honor. If the court would like that case number, it's 2013-01. I told the defendant too that he can call and talk to someone at the front of the court and they can tell him the same thing. I'm not sure if he has or hasn't.
Right. All right, Mr. Lee. Anything you want to say? Can't hear you. Can't hear you. I'm sorry. Can't hear you. Barely hear you. You got to take off your hat when you're in court too. So, sorry. Thank you. Is there a volume switch you can do on that or something? I had wondered if you wanted to say anything, but again, it's really light.
Yes, I was, what the Tracy just said, I was not understanding that, and she did not explain to me that. That's why I was kept asking.
All right. Okay, well, the order does appear to be appropriate. Ms. Johnson, do you have anything to say?
No, I don't.
It does appear to be appropriate because child support will be paid to the mother, not to the former guardian or anything like that. The numbers appear to be appropriate. I did go through the income factors regarding for mother, high school diploma believed available, and she had been earning $17 an hour before. She is seeking employment. I think overall that is appropriate. So it does appear that the numbers are appropriate, and I will enter the order. All right.
Thank you, Your Honor.
Maybe Mr. Lee is all right. He now understands it, and I appreciate it. Thank you very much. We'll enter the order when it is sent to me through DocuSign. Thank you.
Thank you.
Thank you.
Thank you. Knaus, I guess it is now, but the plaintiff is present via Zoom with her attorney, Ms. Pagorsh. The defendant is present here in the courtroom with his attorney, Ms. Baxter. I think we're dealing with a 14-year-old child, if I'm if I'm not real far off.
You're correct.
So far, so good. We have the plaintiff's motion to appoint a guardian to change parenting time and counseling for the child and for the defendant. Ms. Of course, I read your response. I read Ms. Baxter's response, but please feel free to add something if you would like.
Thank you, Your Honor. As you're aware, the court order allowing the move for Ms. Knaus and the child was entered in 2013 when the child was 4. Since second,
Traverse City now.
Yep, since second grade, the child has struggled with anxiety and ADHD. She's been in counseling. She has a psychiatrist, and defendant's relationship with her has really gone south. He's threatened to take her to a mental hospital. He did take her to a mental hospital. The last 2 weekends of defendant's parenting time, the police were called, and he took her in this last weekend that he had her for a psychiatric evaluation. No call on the way to the hospital to mom.
I understand all of that, and I'll do my proper lecturing and all that. He's got to call, not sometime afterwards, but he's got to call when he's going there. That's what legal custody is about. Ms. Baxter, I hope I don't have to say anything more about that, but that has to be done. You can't take a child to an emergency sort of situation and tell the parent, 8 hours later, oh, I took her. So that's enough of that lecture. Any more things that happen like that, then I'm going to really come down hard on either party.
Thank you, Your Honor. I'd also like to address his claims that he has no access to the records, to the My Chart. He's attached them to his response. As far as setting up that's between him, Spectrum, and because DEK is over age 12, she needs to facilitate that as well. If you look at his exhibit, you'll see that it instructs him as to how to set that up, and that's in exhibit H. As for the medical providers, he has their information. It's been the same pediatrician for 11 years, the same therapist for 6 years, the same psychiatrist for 5 years.
Those are all up in Traverse City, right?
They are all up in Traverse City, and he's sent them these letters asking that they provide him with 2 weeks notice or reminders of appointments. That's not on them to do. Ms. Noss gives him advance notice. The appointment that he attended in August, she told him about in April. She's given him the ability to participate. What he's demanding is he wants to just call, and the treatment providers are saying because of HIPAA, they can't just have him on the phone. They need him to be present. He has the advance notice. If he wants to be there, he may be there. He's self-employed and has that flexibility. As far as this medication issue, that's the first red herring that we're going to deal with today. She takes her medications as prescribed. The Concerta is a controlled substance. The doctor has told them repeatedly that she does not need to take it on weekends. I attached a letter from the psychiatrist saying she doesn't have to take it on weekends, yet he insists that she does that, says he doesn't get any information from the doctor. Well, he was there on August 1 when the doctor confirmed she doesn't need it, and he argued with the doctor, psychiatrist, I should say, and then called him unprofessional. He doesn't listen. As far as the second red herring, that's saying that this is about child support, not about child support. Not at all. The friend of the court has already issued its recommendation. They've looked at it. The last change in the child support was 10 years ago. They were well overdue to have that support reviewed. At no point did we ever agree, nor could we agree, to make child support non-modifiable. That's just not a possibility under current law.
Go ahead.
So the situation has dramatically escalated. The parties are not communicating because defendant refuses to communicate directly with mom and wants to go through the child, which is completely inappropriate. There's a whole lot of he said, she said here. And I thought a guardian ad litem could help coordinate all the different parties, including the medical providers, that until the guardian ad litem can get in there and get his or her hands wrapped around this and understand what's happening, I think we pull back a little bit on the parenting time. Mom is willing to drive down on dad's weekends, facilitate the Saturday time and the Sunday time. So he'll no longer have to even drive up to Traverse City, but the Saturday time would be from 10 to 7. The Sunday time would be from 10 to 5, and mom would do that driving. As far as the counseling, I think it would be very helpful if mom and dad participated in counseling as either the counselor directs or as recommended by the GAL to help them. As far as the GAL, I think Samantha Van Tol or Mike Taburin.
I have somebody in mind that I prefer who actually practices in Traverse City and Grand Rapids.
Oh, very good. And finally, Your Honor, I'd like to address paragraph 14. In our motion, we indicated that mom does not give the child the medication, the Concerta, on weekends, which the parties discussed and confirmed was not needed with the psychiatrist. Defendant's response was that it was false. And then he goes on to make these inflammatory false statements about mom's mental health from 2006 to 2008, which is before the child was even born. He's alleging she self-harmed, that she assaulted 2 people with a loaded weapon, that she had.
You think I took any of that into consideration?
Well, Your Honor,
Let me just tell you, I don't think I did. Okay.
Oh,
It's years ago, and I understand that he's going to throw everything against the wall. And I mean, it doesn't play any part in this.
Your Honor, it's not true. I think it was either a very bad cut and paste
Right.
or a deliberate misleading of this court. And I'm going to ask that it be voluntarily redacted. And if it's not redacted from the court file, then I will file a motion seeking fees and sanctions because it's simply untrue. It is libel.
You'll have to deal with that as you do, unless Ms. Baxter and them agree to take it out. You can do whatever you want with it, and I'll go back and try a case from 2006 to 2008 and figure that out. That'll be really productive. I'm trying to get this matter done. All right.
I understand that, Your Honor, but that's public record. And those blatant falsehoods should not be out there.
I don't know if they're falsehoods or not. It does seem like it's not really, Ms. Baxter. It doesn't play any part in this, but go ahead. I'm going to give you your chance now. You can stay seated. You're all right.
Thank you. I feel my habit. I feel a little more comfortable.
Whatever your habit is, I feel more comfortable if I stay seated. Oh.
Your Honor, I can't see her when she's talking.
Uh-oh.
Can you see me now?
Can you see me now?
I cannot.
Uh-oh. That's, there it is.
Now I can.
Can I speak? Does that key in the picture?
There, it's working now, I think.
Yes.
Go
Your Honor, I don't really have much to add to our response to her motion, other than I don't think this is a guardian situation. I think this is a failure to communicate between the parents. I think a mediator is much more appropriate in this matter. I think that from my client's perspective, it's not just the distance to Traverse City here, but my client feels that the order that parties agreed to, and Ms. McCourse represented Ms. Knaus on, which allowed Ms. Knaus to move to Traverse City for a cap of child support of $500, that should stand. These activities with the friend of the court on the child support is disingenuous and in direct violation of the own order that Ms. McCourse and her client negotiated in order to secure an agreement to allow Ms. Knaus to move to Traverse City. That's public record. That's in the court file. That's also been attached to both of our motions. The issue about the medication is clearly an issue about joint legal custody. My client and I are well aware of what the aspects of joint legal custody are. Joint legal custody are that both parents are to be treated equally. Both parents are to have equal information and equal access to information. Our motion indicates clearly that Mr. Camps is not able to access information clearly. He has contacted these medical providers in Traverse City and been told by these providers that they cannot give him information unless they talk to Ms. Knaus first. As recently as this week, they had a parent-teacher conference, and Ms. Knaus did not notify Mr. Camps about the parent-teacher conferences. He called the school about the parent-teacher conference, was told when it was, and they were told that they had to talk to Ms. Knaus about this. Never got back to him, so he was not able to attend the parent-teacher conference. It's difficult enough with the distance, but it's even more difficult when he believes that he's being blocked from participating in his daughter's education and healthcare provisions. One of the things that is causing a lot of stress and is admitted by Ms. Knaus in her pleadings is this issue about the medications.
The prescription bottle states is written as the doctor ordered it, that this medication is to be given on a daily basis. There is an issue about when and how it's to be given or whether it can be skipped on weekends. There's nothing written or given from the doctor about that. And it is causing a lot of stress, not only between Mr. Camps and Ms. Canals, but also the daughter, Davany, because on one occasion when on a visit with Mr. Canals, Davany wouldn't take the medication. She says because she thought it was her mother's pills. The issue about medical mismanagement is the reason this information about Ms. Canals' past is concerning, is because that was a significant issue for.
It was 15 years ago. I don't care what.
Well, I
15 years
understand, but
ago.
there's context.
It was even before the child was born. I don't care. Just
All right.
telling you.
All right, well, that the issue.
So if somebody says stuff about 15 years ago, what I did, I might have got my ear pierced 15 years ago and hated that. So I've done
But that was
things.
true, wasn't it?
I don't know.
I think it was true.
Yes. All right.
So the context of that is important, and that's why that was put in there.
And-
It's public record and factual at the probate court on her involuntary commitments and that sort of thing. That was not libel. That was not slander. I'm sure Ms. Canals remembers.
You guys can talk about that. That's
just wanna-
something that I'm not going
there's
to issue here.
something Accused of false information in my pleading. That's public record at the probate court. So I guess what I'm saying here is I don't think this is a guardian situation. My client is more than willing to have a mediator here. There clearly has to be some help here because the communication between these parties is terrible. My client wants to be more involved in his daughter's life and feels he's being blocked by Ms. Canals to do that. In addition to the distance, and it's causing a lot of stress on their daughter. A client does not wish to give up any of the parenting time. One of the issues is Ms. Canals has called her daughter on one occasion, and we have screenshots of the calls 16 times in one day to her daughter during her father's parenting time, which causes some stress and prohibits Davany from developing a relationship with her father and enjoying the time when she's there.
All of this tells me that I need more information, and I'm going to appoint a guardian because it just, I mean, to go to a mediator, they go back and forth. I don't appoint many guardians, but in reading through this case, I think because there's medical issues, because there's who can get information and what information, I'm going to appoint a guardian to get to the bottom of it. And
we welcome any help.
I mean, I wasn't. There's one thing that bothered me when I was reading it. It was, I don't know whether or not it was my counselor or somebody said the 13-year-old needs to be more involved in when she has to go visit her dad and stuff like that. I completely disagree in that kind of stuff. These are still the parents and they need to work the stuff out. I intend to appoint Mike Dunn, who actually lives in Traverse City and practices in Traverse City and Grand Rapids.
I think that's an excellent choice.
And Mr. Dunn will be able to get together with all the appropriate providers and everything up there because he's there most of the time, but he does also practice down here. He has done some guardianships. I actually went so far as to contact him before to see if he would even accept it. He said he would. So I'm going to have Mr. Dunn as appointed as guardian with everything that goes with it. I believe the two of you can work out the order. He's got to have access to everybody and everything so that he can come up with something. I'm gonna, I told him I need something sooner rather than later. I don't want this to drag on for 6 months because I don't intend to change parenting time or anything during that time. I think hopefully he will get involved with it. And if there's reason to change parenting time, he'll send me something about it. And if he does, he doesn't get to make any of these decisions. He can only make recommendations. All right. So that if Mr. Dunn were to say, wait a minute, I'm not going to suggest any overnights. It'd be up to you, Ms. Pagorsh, to come back and ask, because he's not going to just get a blank check. Okay. Each party will be responsible for one half. I did not really figure out how much, but both Ms. Baxter and Ms. Pagorsh, I would ask you to contact Mr. Dunn, or I'll have him contact you. I don't care what. And he'll tell you what needs to be put down as a retainer. I'm sure it's going to be $1,500 to $2,000 type stuff, and it'll have to be paid promptly so that he can get to work. I want him to have full access to medical records and whatnot. I'll find out whether or not she has to take Concerta or not, whether or not it's, whether it's recommended or not recommended or whatever. I really feel like, otherwise I'm gonna end up being the parent in this case and going back and forth, and I don't really want to micromanage this case. We need to get to the bottom of this. And so that's my intent, is to have Mr. Dunn appointed. Any objection to that, Ms. McGorsh?
No, Your Honor, I just for one clarification is Dunn, D-U-N-N.
Yes.
Okay, very good.
Michael Dunn?
We have no objection to Mr. Dunn being the guardian here, and I think that's an excellent choice.
Thank you.
I would like to ask, we're denying any change in parenting time.
However, I do want to say something before I forget, okay? And you'll remember what you want to say to me, but I won't remember, so I got to say it now, okay? And that is, if your daughter, I know there's this stuff about dance, okay? That's out there. If your daughter has a dance recital or something like that on a Saturday in Traverse City, and it's your parenting time, she better get there. You better get her there, and either through Miss Knaus or you, okay? I'm telling you right now, that's an activity that I don't care whether she's a ballerina or not, okay? But she will participate in that. Does she have practices every weekend or something? I mean, all right. All right.
I have to interject here. In a part of our motion, we submitted pictures of him attending dance.
That's fine.
Dance class. He does that.
He does that, then there's no problem. I'm just stating right here, because there's questions about whether he does and whether he says she's a crappy dancer or whatever. I don't care. I'm just making sure that from my standpoint, if you're doing it already, then you just shake your head and say, yeah, I'm doing it already. What's the big deal? End of story.
I would like to ask, though, that Ms. Knaus be reminded that joint legal custody means Mr. Camps has access to the medical records, school records, and the providers. For example, if you hear me out, my chart with now Corewell Health, Ms. Knaus changed the password so they can't share.
All right. Let me tell her that he's got to have access, okay? And Ms. Pagorish, I don't care how it is, whether it's changing passwords or whatever. I mean, it's a struggle for me to get on my own thing here at whatever it is. I just have to make sure that promptly, and Mr. Dunn can address this too, okay? He'll address this. He must have access to my chart or whatever in the heck it is. And if he calls my chart and says they need you to call him and do something or another, then you got to do it. I'm assuming that if you don't, you should talk to Mr. Dunn about it right away, and he will make sure that that's going to be something that has to be done. Okay.
Your Honor, the instructions for how he sets that up are in his Exhibit H, page 2. He may need, like Ms. Knaus needed, the child to call in to authorize him because of HIPAA. Children ages 12 to 17 need to call in and authorize. So that's between dad and daughter. Not mom.
Dad and daughter and mother must also, these are the parents of the kids, okay? I'm not going to give her the ability to be the parent in this relationship, all right? The mother and or father will see to it that he has access. End of story, all right? I don't care what you have to do it. She does not get a chance to say dad doesn't get to see anything, all right? He should have access to it just like mother does. I don't care how it gets done.
I agree, Your Honor. I'm just saying Ms. Knaus didn't block it.
All right.
May I ask one more question? These pills on weekends. Can Ms. Knaus just send the pills in the correct prescription bottles instead of plastic baggies all mixed together?
That's fine. That's fine. That's fine. That's the only other thing. Send all pills in prescription bottles. I don't know how many she takes. This is going to not last very long because it'll be one of the first issues you should deal with Mr. Dunn. All right. Send it in appropriate pill bottles. I don't know how many she has to take. I'm not her doctor. I'm not going to be trying to make a decision on that at this point. It is something you can discuss with Mr. Dunn.
Your Honor, the most current pill bottles are at the school because that's what they require, because she takes the pill in the morning and then at noon at school. So that's where the most current ones have to be. As far as the Concerta, Mr. Camps has filled it now in August and September, and he has a 60-day supply, yet he has her every other weekend. So he should have a volume of Concerta.
We have one Concerta, and what we get every weekend from Ms. Knaus is a baggie of mixed pills.
That is not correct.
I called for a 2-day script from Dr. Wilkinson. He gave me a 30. The first time, since Anna's
All
never
he wants to know
provided
is,
me
do you have them?
her medical card or anything else, I had to pay out of pocket $300. We sent those pills back. The second group we kept when I asked for 2. So I do not have 60. I have 28 left.
Of one
Of
prescription.
one.
All right, he has 28 and you don't have to send any of those down. Because he's got them and I don't know what he's gonna do with them. You better follow whatever it says. And you should be talking to the psychiatrist, the psychologist, whatever, to determine if she really needs them or not. If you're giving her some that are not necessary, that's not gonna go good for you if you're, but I'm not making that decision because I don't know,
I'm
okay?
just asking, did we get something other than a plastic bag full of pills?
Do your best, yes, you should have some type of, to show what it is, all right? Shouldn't send down a plastic bag full of pills. I understand what you're saying, Ms. Pagorsh. If you have to go to the school and get a, picture of it and put it in a specific thing and whatever it is, just make sure he knows what it is, all right? That's
Very,
just common
very good,
sense.
Your Honor.
We'll work with it, all right?
Try to get
And-
this done there.
Yeah, Ms. Pagorsh and Ms. Baxter, you guys gotta talk. The one thing is, can you get me an order sooner rather than later about the appointment of Mr. Dunn? All right, so that we can get going on this.
I will work on that and get something out, if not today, first part of next week, to Ms. Baxter, so she can review it and we can hopefully agree on the language of the order and then get it sent to you and then up to Mr. Dunn.
Yeah, and if for some reason you have some problem with language, call my office because I'll get you in here in 15 minutes on Zoom or something, because I want him in this case. All right, man, I want it going. Sometimes I get these guardians and it takes 4 weeks to get an order in, and that's just 4 weeks wasted.
Right.
Right.
I'll be happy to work with Mr. Doris to facilitate this. We think this is.
I think both of you, we're all on the same page. We all want the same thing for the child. It's maybe different ways that we're willing to do this. So please work with Miss Baxter. She said she will be happy to work with you. In fact, she smiles every time I tell her to. She can't wait to work with you, Ms. Gorsh. And look at that. If that isn't a sign of good faith, nothing is.
Yes, ma'am, Mary.
Very good. All right.
All right. Good luck, everyone. Take care.
Thank you.
And we'll be seeing you in the future, I'm sure.
Thank
Take
you.
care. Thank you.
Good. Thank you. Bye-bye.
Yes. I thought you'd retired and gone to Bahamas to live very soon.
I wish I would've let you know.
Hello, everybody on YouTube, those out at the campground place in Romania and Traverse City and all the appropriate people. Good morning. This is Mr. Peterson. You showed up this week. Nice.
Good morning. Yes, I actually got notice this week.
Allard v. Allard, both parties are present with their respective attorneys, Mr. Peterson, Ms. Camfield. We adjourned this from 2 weeks ago, reluctantly. But this is simply a matter of getting a quadro entered. And I'm just gonna go to you, Mr. Peterson. Why can't we get a quadro entered?
So there are two of them, one for a pension and one for a consumer's energy plan. The pension, originally, we couldn't get it entered because when the quadro was drafted, the wrong pension plan name was on there. We reached out to Mr. Crow's office, let him know, didn't hear anything back for a long time. And then so that one's been signed at this point. The pension plan has been signed. And so now we're down to the consumer's energy plan. And the issue there is that there was a loan against that 401k. The loan was taken back in 2019 by the parties during the marriage. The loan was originally for $14,000, and that loan was used by the parties during the marriage to acquire some property that was later accounted for and sold with the marital home. It was property that was right behind the marital home. And so what we're left with here is a judgment of divorce that doesn't indicate anything about the 401k loan. But I think it's fairly clear in MCL 552.101, paragraph 4, that indicates for any divorce or separate maintenance action filed on or after September 1 of 2006, if a judgment of divorce or judgment of separate maintenance provides for the assignment of any rights into any pension, annuity, or retirement benefits, a proportionate share of all components of the pension, annuity, or retirement benefits shall be included in the assignment unless the judgment of divorce or judgment of separate maintenance expressly excludes one or more of the components. And so the argument here is, should the 401k loan balance on the date of valuation be included or not included? And certainly it's our position that it should be included. The balance on the valuation date, $6,285.08. And so that balance of the 401k loan should be taken off the overall balance before separating. And so that's
But
why
it says in G, as I'm understanding, G, it says defendant's 401k. Isn't that the paragraph we're dealing with in the judgment?
Yes.
It says plaintiff is awarded, and it's specific, 50% of the defendant's 401k plan through that, okay, through consumer's employee, which accrued during the marriage to the date of the valuation. There's nothing in there that would indicate that that was to be changed, the valuation plus or minus any gains or losses from the date of the filing of this divorce to the date of distribution. There was nothing reserved. There was nothing said, anything other than 50% goes. And now if we get into this, I mean, every time, this is the second one today I've heard, and people are going, well, wait a minute, we got to consider that there's got to be an end to this. We can't have a 50% go where there is nothing reserved. There is nothing in the judgment that says, hey, if there's any loans or something like that, it just says a straight out 50%. And I think that's what I've got ordered.
Well, I think that's what it is. I think that's why MCL 552.1014 addresses that. It says if the judgment is silent, that it still has to include all components.
The judgment, I don't think is silent. It just says 50%.
Correct, 50%, but 50% of his balance would be the $148,000 minus the loan that the parties took out.
I'll let Ms. Camfield have her say.
Well, Your Honor, thank you. I don't agree with Mr. Peterson respectfully. I agree with the court that I think that the language in the judgment is clear. Statutorily, if they wanted to bring this up and argue that the loan should have been included, the time period to do that would have been at the signing of the judgment, which was, by the way, a consent judgment. On August 1st of 2022, counsel signed, as did his client. My client signed August 9th and her former counsel August 15th. So the time and the court's signature, August 31st of 2022. The appropriate time to have brought this up to the court would have been within the 21 appellate days thereafter, the judgment being signed by Judge Hillary. That did not occur. And in this particular instance, this is something that could have been resolved last year during the judgment signature and drafting. And I don't think statutorily that includes the loan under that provision.
Let me ask you, Mr. Peterson, wasn't it, this is your client's 401k, right?
Correct.
And he's the one who would have had access to the 401k for all the information.
Yes, everybody had access to that 401k. That's true.
But I mean, it would come from him.
Absolutely.
So why would not he have objected to this back whenever, even before you got to a consent judgment, or said, hey, I got $14,000 loan and stuff like that? It was within his information. And I wouldn't expect Ms. Allard to be going, okay, yeah, we'll do that. She just wants her half.
And she would get her half. There's no doubt about that. These parties had that loan that they took out together to buy property during the marriage. She has certainly gotten her half. She got half of the equity in the marital home and the property that was acquired by the parties taking this loan out. That was all appraised and everything was taken care of. I think it's also interesting, and this was addressed way back when, but and I have a text message from about a year ago from Ms. Allard saying that, yes, she was in agreement with the loan. So
before the judgment?
I'm sorry?
Is that before the judgment?
After.
After the judgment, she says she's all right with taking it out of the pension, if you will?
Out of the consumer's energy plan, yes, not the pension, but the consumer's energy plan, the 401k.
She said she was all right with that?
Yeah, Thursday, September 21 is the date of the text, and it's text between the parties. and they're talking about it. And she indicates in there that we can agree, yet the attorneys won't write it up and get it done. And she's talking about the loan or the retirement minus the loan.
Allard, did you state that stuff in there? I mean, it sounds like he's got it.
Sounds like what?
Sounds like he's got the text from you and stuff like that. Do you agree?
We discussed it. I wanted to get it done. This has been since February and he's not trying to get it done. And he always tries to stiff arm me to get his way. So I just want whatever it says in the judgment.
Well, but did you agree to take, I mean, if Mr. Peterson's gonna show me something that you agreed that the loan should come out and stuff like that, why wouldn't?
I don't agree that it should come out. I don't think it should. I want it to be done. This should have been done a long time ago. I don't think it should come out.
Could have been done, and I'm trying to get it done. Don't go there with it. I'm trying to determine that if you agreed to have it come out and be made part of it, Mr. Peterson, did she agree, or were there what?
Well, and that's unfortunately, Your Honor, I don't have copies of any of those texts or communications that Mr. Peterson's referring to. And respectfully, we adjourned this for 2 weeks so that I could resolve this matter. And it seems like that should have been sent to me if there were communications that I could discuss with my client. So we're once again delaying this matter in order for those to be sent to me. And he and I have been communicating by text all morning. Well, I still don't have that.
Well, I mean,
that's how we got the initial pension signed. It wasn't signed by Mr. Allard until today, Your Honor. And only in the hopes of preventing the hearing.
Mr. Peterson, why wasn't that done before today, the pension?
The pension wasn't done, as I mentioned before, because they had the wrong pension name and wasn't notified of the last hearing. So I didn't see any corrected documents, I don't believe, with a correct pension on there. The pension quadro was also wrong because it initially said that Miss Allard was to receive 50% of the pension, but they didn't say anything about 50% of the marital portion, which it now does. So that's why that wasn't taken care of.
So those corrections were made, Ms. Canfield?
Yes, they've been made. In fact, I would have to go back and look at I don't have access to my legal assistant's emails. Ms. Aldrich took care of those weeks ago, and prior to the last scheduled hearing.
How long were those taken care of, Mr. Peterson?
I don't know, because I was never notified of the hearing nor sent the updated documents. Once my client was at the hearing last week and texting me saying, "Are you coming to the hearing?" And I told him I didn't get any notice of the hearing. That was the point when I realized that the corrected pension documents were sent to him, but not to me.
All right, and you didn't show up just because you didn't have notice?
I didn't have any notice, and then I was in court in Ottawa County.
Just because you didn't have notice.
I'm sorry, what was that?
What a weak excuse. You didn't have notice.
Yeah.
All right. Well, I got to get this done. All right.
Yeah. In the text, Referee Frederick, the text says, "It's been so long, I don't remember what was wrong. 401k, the loan should be 50-50. It seems like something else, but maybe that was it. And my retirement, it said 50-50. It should be 50-50 the marital portion."
You can exchange that information with Miss Canfield. I'm going to try and find a half hour sometime in the next week or two that we're going to meet and finish this. Ms. Canfield, are you going to be available over the next week or two?
Well, that's the problem, Your Honor. I will make someone from the firm available. It's just that I have multiple evidentiary hearings and trials in the next.
I have multiple and many as you do, and I'm going to put it in at noon if I have to, or 8 o'clock in the morning, which I'll be late for, but I'll be there, whatever. You make sure that we will contact both Mr. Peterson and your Mr. Crow's firm, I guess. And we're going to set Mr. Peterson. Are you going to the islands or anything over the next week or two?
Not until the week before Thanksgiving.
Well, we're going to have to try and schedule something. I want all those emails sent to Miss Canfield or whoever. She's going to get them to you promptly. You should be able to scan them in and send them to her today.
Yeah, I just have it's a text, but yes, I'll send it to her. My client just sent it to me this morning. So
and we're gonna call both of your firms and I'm gonna get you in here for a half hour and I'm gonna get this done.
Thank you.
All right. figure it
Sounds
out.
good.
I make a ruling on it, whether or not I believe it's appropriate that half comes out or not, and then you guys can take it from there. But I'll hear some exchanges from you between now and then. Good luck, unless you guys can come up with an agreement, that would be wonderful. But
We've proposed an agreement,
well,
this
we'll see
morning,
what
but
happens. Knowing
Thank
what
you, Gunnar.
down there, I'll be in touch. My office will be in touch.
My client's position is that she's against any kind of extended parenting time at this point. The situation was they were in a very toxic relationship involving physical and emotional violence. And when the child was born, she escaped to Indiana, and she hadn't lived there long enough to do any court filings on her own. But she has established herself in a safe, stable environment with a job and very appropriate work-related childcare, and wants to make sure or be protected from the child being taken from her and not returned by plaintiff. If the court wants to order some parenting time with plaintiff's mother involved, perhaps we could do something, but she's very concerned about the safety of herself and the child.
Where does her mother live?
¿Dónde vive su madre?
No, I meant, I believe plaintiff's mother came with him to Indiana.
His mother lives up here?
La madre del demandante se presentó, vino con él.
I think so.
All right.
Yeah. She's against parenting time at this point, so.
Well, he's entitled to parenting time. I'm gonna terminate his rights, basically, because that's what it'd be. If he doesn't get the chance to see the child at all, and he needs to build a relationship.
But I understand that, Your Honor. I fully do.
Sir, what's your request?
I'm going to try to say English, and then you can just go ahead and jump in if I need you to translate.
Okay.
Okay. The thing is that right now she said all this stuff, and because she's mad, and I got proofs. If Your Honor, like, you let me show you pictures of all these past days after I even got here to set up like all this. Well, we've been hanging out. We didn't, like, there was lack of communication. I was trying to work out things with her, but she can't be the only one taking decisions for my son, because behind her is his mom and his brother, and they let me out of everything.
I'm asking, what kind of parenting time do you want?
¿Qué tipo de tiempo de visita usted quiere?
Because my understanding, the child is nursing, is that correct? That's one of the factors I have to consider.
Okay, yeah, I understand that, and
Entiendo eso.
also, like, it's fine. Like, I want to keep him as much time as you permit me, and
Está bien.
How far away how far away does she live from here? Mr. Watkins, how far away?
¿Qué
She lives in Goshen, Indiana. Let me.
Ma'am, how far do you live from here?
I live about 2 hours, almost 2 hours.
like every weekend, spending on my checks. It doesn't matter. Like, I know, like, I had to do this at first. The only reason I didn't come here and do it was because I wanted to work things out with her, and she was fine with it. But the thing is that she don't got communication with me. Like, and now it's like, I didn't even know what to do no more. She left each other. She let me know that she didn't want nothing else. So the only reason I came here and started everything. And now she comes up with all this, like, I was aggressive or stuff like that. It's not true. She would come and stay like 3 days here at my house after we was already done. Go to Indiana, ask for a favor to stay at one place to go out with them, because I couldn't be able to go inside his brother's house. And honestly, like, I'm here just to, like, know, like, how much I gotta give her, and then how much time I'm gonna spend with my son. I know she's nursing him. And honestly, I've been talking with the babysitter, because she don't respond for no text after I started this. She don't let me know nothing about my son, and really emotional, because when I went to therapy was because I wanted to, like, have a better communication with her, and then I was, like, trying to invite her to come, like, or take some therapy too. But she didn't want to, and now it's like
I can't make her and you get along.
Yo no yo no la puedo hacer forzar.
I've got to start figuring out what to do. One of the things I am going to do is refer this to the friend of the court for custody, parenting time, child support. I'm going to waive the fees for both parents. We'll interview both of you. They will interview both of you and come up with some type of a decision. In the meantime, I'm going to allow father to have some time with the child. I'm trying to figure out how. Ma'am, if you want to bring up the child every Saturday so he can spend all day Saturday, and I'll even say that he'll do it at the mother's house. Would you visit at your mom's house if she brought the child up here?
Visitarías la casa de tu madre si traen allá.
All right. I mean, every Saturday from 10 o'clock till I'm assuming he could see 10 o'clock till 6 o'clock every Saturday.
Cada sábado.
Because I'm assuming you could pump and he could probably feed some. Is that correct?
I was waiting for my client to answer that question, but
¿Están pidiendo que yo lleve al bebé cada sábado a Michigan?
You're asking me to take the child every Saturday to Michigan?
Got to figure something out.
Yo no puedo manejar a Michigan.
I can't drive to Michigan.
Ever?
Nunca.
¿Por qué no lo hacen que él venga? Él puede manejar para acá.
Why can't you make him for him to come to me? He can drive over here.
Where's he going to visit then?
Él puede estar aquí en la casa.
He can be here at my house.
Well, that you just said he's violent and all this kind of stuff. He can't be there.
Pero él puede estar con supervisión de alguien.
Well, he can be supervised by someone.
Who in Indiana is going to supervise him?
Can he go to a person that person can supervise a child?
I don't know that he needs supervision. He just wants to be a dad. Not going to hurt the child.
Y saben que él tiene cambios de humor. Saben que él necesita terapia psicológica.
Do you guys know that he needs psychological therapy and he's bipolar? I'm afraid, and I don't know what he will do.
If he comes down there, where is he going to be? I'll do every other weekend. One weekend you can come down there and one weekend you can come up here. Let me ask you, where will you go if you go down there to visit the child? Well, sir, I can't fix every problem.
No puedo arreglar todos los problemas.
Okay, you're going to have to make some sacrifices.
Tiene que hacer sacrificios.
That's one of the main things that I had, like when we was like in there, I was kind of like telling like didn't have her license and everything.
Okay, but I'm not going to make her drive all the driving. Okay, it's your child.
Yo no voy a hacer que ella esté manejando todo el tiempo.
I'm trying to get you some parenting time. It's getting to be difficult. All right.
Está llegando a ser difícil. ¿Está bien?
Mr. Watkins, I think each party has to do some type of transportation. And because normally if they were here in town, both of them, I would give him a couple days, a few hours on a couple days and some on Saturday. And you're aware of that's what I do. But because of distance, I'm going to have to make some kind of a change. And I guess I can say he can see the child from 10 o'clock till 6 o'clock every Saturday. And every other week, she can bring the child up and he can go down there. And that's just until we get the friend of the court. All right.
Understood.
Exchanges up here can be at his mother's house. And can he pick up the child at your client's house or is she willing to have him at her house?
¿Puedo hablar?
Can I say something?
Mr. Watkins?
Only if giving an, we need to know, can he come to your house to pick up the child? Or are you willing to have him stand up?
Can he visit the child at your house, ma'am?
Señora?
Sí puede.
He can.
All right. Then every other Saturday, you go down there and you will be respectful at that house. Do you understand? And on the off weekends, you can she'll come up here to your mother's house, drop the child there.
Casa de su madre.
If you don't want to visit down there, then you don't have to.
And Your Honor, when do you will this start?
Next Saturday.
Will that be a Michigan or an Indiana visit?
I can be in his house because I don't feel safe in his house.
Safe in what house?
¿Seguro en qué casa?
En la casa de él en Michigan, ustedes no saben todo lo que yo pasé.
His house in Michigan.
Embarazo.
You're not going to be at his house in Michigan. You're going to drop the child off at his mother's house where he will be. Pick up the child at 6 o'clock.
Y usted recoge el niño a las 6 de la tarde en la casa de su mamá de él.
Y cuando mi bebé quiera comer,
And when my child wants to eat,
when your child wants to eat, I assume, Mr. Watkins, I assume you can pump milk that can allow him to feed the child.
yo siento que puedo encontrar una forma para que él
It'd only be once or twice every other week. I assume that you will pump milk for him to be allowed to feed the child while the child is at the mother's house.
yo quisiera que ustedes me entendieran como mamá,
I would like you to understand me as a mother.
que mi bebé no es seguro con él.
That my child is not safe with him.
Él le grita hasta a su propia mamá.
He even yells at his own mother.
Y tengo pruebas. Yo no
And I have
solamente estoy inventando cosas.
I'm not just making things up.
Mi bebé no está seguro ahí.
My child is not safe with him. Safe there.
He's not going to hurt your child. It's his child.
Él no va a lastimar a su hijo, es hijo de él también.
Yo entiendo que es su hijo.
I understand it's his child.
Pero ¿por qué no puede yo llevo el bebé a Michigan, pero él salir a verlo a una casa de una tía mía? Pero ¿por qué tiene que estar ahí? Yo necesito tener.
I can take the child to one of my aunt's house. I need to have a person that's going to be supervising him because I don't know what he's going to do.
His mother is going to supervise, just like you said to begin with, that it could be his mother.
Su madre no está bien tampoco, porque ella permitía, ella sufrió violencia doméstica en México. Y ella cree que todo lo que él hace está bien, solo porque es su hijo.
And she thinks that everything that he does is fine because he's his child.
Ma'am, it's the grandmother and the father. I'm going to assume that they're going to be taking care of the child. Mr. Watkins, it's getting pretty clear that she doesn't want dad to ever see the child, except on any terms that she has.
Parece que ella no quiere que él deje ver al menor.
I'm going to try and get this to the friend of the court as soon as possible.
Lo vamos a mandar al friend of the court.
In the meantime, that'll be the order every other Saturday, one Saturday up here, one Saturday down there.
Mientras tanto, esa va a ser la orden hasta las 6.
Times in Indiana will be at her house, and the time up here will be supervised by his mother.
Y en la casa acá va a ser supervisado por la madre.
All right. I know your client's not happy. She's never going to be happy with anything I say.
Yo sé que su cliente está contento, nunca va a estar contento.
But it's the order that I'm making. You may need to talk to your client about some stuff.
Pero
right?
es la orden que estoy poniendo y probablemente se tenga que hablar con su clienta.
And again, it starts next Saturday, and is that in Michigan or Indiana?
Empieza el próximo sábado. Su decisión.
Next Saturday in Indiana.
Okay.
El próximo sábado en Indiana.
All right, and I will put that order together then.
All right.
Voy a preparar esta orden. Gracias.
Thank you. That's what the order is going to be. All right.
Eso es lo que la orden va a hacer.
Look for the friend of the court information. Good luck, everybody. Mr. Watkins, if you can give me that order, I'd appreciate it.
Suerte a todos. Si me puede mandar la orden, lo apreciaría.
Good luck.
Buena suerte.
Thank you. We're adjourned.
Thank you, John.
Thank you, Mr. Romero. Yes, it's done. I can't hear more stuff, okay? We're gonna try and get a resolution.
And when can I start again? So what can they do on?
Next week, Saturday, you go to Indiana.
Well, this weekend.
Nothing, because we haven't started it yet. I won't have an order. Next weekend. Good luck.
I got some posters just in case.
What?
I I got some code for him just to know, like,
You-
also, like, can I send it with someone else?
You can send it, goes, you can send it by mail, you can do whatever you want. We're gonna work on this. Both parties are present. Thank you. Mr. Quano is here in the courtroom and, Ms. Quano, or formerly Ms. Quano, is, present with her attorney, Ms. Wolfram. Give me a second. This is simply a motion by mother to change legal custody. Ms. Wolfram, you've cited several incidents where the parties just cannot agree on everything, and I'm gonna be forced to make every decision, including dosage on current meds, enrolling in driver's training, orthodontics, ADHD evaluation. Mr. Quano, did you see his responses, Ms. Wolfram?
I've received 4 of them. If that is the total amount, I've received them
I
all.
think I received 3, but oh well. The first one basically saying you didn't pay the fees, so I shouldn't hear it. That's the court up, that's up to the court, and that had nothing to do with you. As far as other things, he's talked about orthodontics, why he doesn't necessarily agree to it, talked about the dosage increase, indicating that using drugs, that mother uses secularistic beliefs to deny God in the lives of the children, using drugs to replace God's divine interaction, such and such. Driving says it's too young, and ADHD evaluation, I don't know why, I can't imagine why it's against it. Do you want to add anything? It's just a Vidvarka type situation that it's pretty clear the parties do not get along, and I'm gonna have to do something, but I'm gonna ask Mr. Quano for his brief response. Anything you wish to add, Miss? Because I know what's going on.
I appreciate it, Your Honor. I guess I would just tell for the record that since the filing of this motion, and as this court just elucidated, I think it was his second response, which referred to why he disagrees with orthodontics. He's now unilaterally. Oh, can you hear me?
Some, don't interrupt.
Oh.
No.
I'm sorry.
No, it's not you. I just somehow lost my connection here. So I could hear you, but I can't see you. And I'm trying.
No worries.
Just a second. What did I do? Join the meeting? What? Huh? Just launch the shuttle. It's on its way.
Yeah.
And hopefully it has a safe landing. All right. What is it you want to add? Sorry, I just lost you for a minute.
No worries. I guess just for this court's, knowledge and context, per the court's recent recitation of, I believe it was the second response about why he doesn't agree with orthodontics. We just found out yesterday that he's unilaterally scheduled some appointments with the orthodontist without confirmation with my client. It just goes to the perfect example of why these parties simply cannot get along. They are just not meeting in the, we're just not, we're not nearly on the same page whatsoever. And the last response that this court seems not to have received is 17 pages long of the similar types of recitations that he makes in the other ones, which, it just, again, support the fact that these parties are not able to come to a decision. And I guess I'll just once again reiterate that they have tried mediation, and it is an abysmal failure and an opportunity for Mr. Quano to abuse Ms. Hodgkinson.
All right. Anything you want to briefly add, Mr. Quano?
Well, I first want to point out that settlement information is supposed to be barred under Michigan Federal Rule of Evidence number 408.
Okay, you can educate me on the law at some other time. I know it better than you. Go ahead.
I'm sure you do. Okay, so we're gonna admit this.
Admit what? All I'm asking is whether or not the two of you can get along. There does appear to be Vidvarka to have an evidentiary hearing. I'm not going to change the legal custody here today. I have to have an evidentiary hearing. And it pretty much, I mean, your answer says you don't get along on anything.
No, that's not true, Your Honor.
Yes, it is.
Well, we've agreed on a great number of things, including homeschooling, most recently, the last couple of weeks, vaccinations, which a lot of parents don't agree on. There's a whole long list of things we've agreed on, and these few items, I'm waiting on some responses from her. And she mischaracterizes how I'm trying to work with her. For example, saying that unilaterally scheduled appointments, I did not. I made very clear with the orthodontist. I was penciling things in so we didn't lose time, so that when they would talk to me, we would still have options. That's not unilaterally deciding on things. That's me trying to work with her. Every time I try to work with her.
Well, maybe it's her that won't work with you and we'll figure that out at legal custody.
What does that mean, Your Honor?
That means that the two of you don't work together. And as a result, I have to have an evidentiary hearing whether or not legal custody should remain with both of you. Maybe it should go to her. Maybe it should go to you.
Is that an option, sir?
What?
Your Honor, is that an option?
What do you mean? Legal custody, I have to determine who it would go with.
Realize that.
Well, I thought you knew the law. You were quoting it to me earlier.
I don't know as much as I'd like. I'm still learning. I'm sorry.
So I don't think there's any way that I get around the fact that, I mean, you now tell me that she doesn't work with you. And so there is no way that I'm going to be involved with this case for year after year, making the decisions, because next thing I know, Ms. Wolfram is going to file a motion to say he needs to have his dosage increased. He won't agree to it. So I got to make the decision. And that's what it comes down to. And then the next thing it's going to be, you don't agree to have them start driver's training. So that's a decision. You don't agree she does. So I'm going to have to decide it. And I'm going to figure out what is appropriate or not. The two of you do not work together, no matter what you say, or at least on a majority of the stuff. And as a result, I'm going to have an evidentiary hearing regarding legal custody, whether it should be changed, whether it should be in one person or another.
Your Honor, can I ask about the motion they submitted? Said that, again, I don't know the law that well, but I'm gonna ask, they said that it would be tried on preponderance of the evidence. But it doesn't look like the law says that it should be on clear and convincing evidence, which is a slight.
We'll find that at the time that it happens. Miss Wolfram can say it could be based on, anything she wants. We'll find that at the time of the hearing.
I have requested relief that they'll be got in, but well, one of my reliefs is that the children are struggling in math and she's refused to send their homework with them, and I was just asking if I could be in order that they be send their.
How often do the kids see you?
Well, you ordered that it'd be every week.
For how long?
For an hour and a half. You have time to work on things, eat dinner.
If she thinks it might be appropriate, fine. I'm not going to get involved in micromanaging at this point. If the kids have homework and you want to send it, fine. If not, fine. You should spend some time with your kids. That's where we're at. I'm going to set an evidentiary hearing regarding legal custody. It will not be real soon. So if you need to have the dosage or something dealt with, you're going to have to file a hearing here. And I don't know if I'll get you in any faster for that. All right. That's just, I don't have that much time out there. I'm scheduling out into February, I think, but I will get in for an evidentiary hearing regarding legal custody. Good luck, everybody. That's the ruling of the court.
Thank you.
Welcome back. Thank you. We'll be in contact to set up. Ms. Ellenwood, are you driving?
No.
Oh, he was speaking to your spouse, former spouse.
And I can't hear you. Ms. Ellenwood, could you hear me? You're on mute. Yes. Are you riding in a car?
I am. I'm pulling over right now. Sorry, I had to go to work today and it had been 2.5 hours.
This is case Ellenwood. Will proceed as soon as Ms. Ellenwood pulls over in her car. Both parties are present via Zoom. Mr. Ellenwood is represented by Mr. Cox. We were informed that Mr. Zweers would not be appearing on behalf of Ms. Ellenwood. And this is the defendant's dad's motion, or the defendant's motion to enforce the judgment of divorce. The judgment of divorce calls for refinancing the home within 90 days and for him to get certain sports cards, tools, toolbox, and tire changer or something. And he says to this date, he has not received, I think, some of his tools.
Yes, Your Honor.
And the defendant is to pay $30,000 within 90 days, and it hasn't been done. Is that still true, Mr. Cox?
It is, Your Honor.
And the judgment of divorce was from, what was the date? The 90 days it started from, sorry.
No, it's okay, Your Honor. It was entered on June 21st of 2023.
Ma'am, how come it's 90 days and you haven't complied?
I am been in the process of trying to get a loan for the refinancing of the house. It's been a difficult process because I did not have my own income. We owned a business together and he took that business with him. So then I was left with no income to show. Then I did start my own business, but I have to have it in place for 2 years in order to be eligible for a loan. So I am now looking through a private lender to put my house up as collateral for the loan. And I'm in that process right now. When it was due to be done at the 90-day period, my mortgage broker reached out to Mr. Cox and asked for an extension on things and explained what was going on. And they did not want to agree and instead filed papers with the court for this hearing.
Was this a consent judgment, Mr. Cox?
It is, Your Honor. We resolved the case actually back in March of 2023 with Mike Dantema.
Ma'am, here's the problem. You agreed to it, and now you turn around and say, I need more time. That order speaks for itself, and it has to be done.
I know.
Then he can come in and sell the house.
I have given him everything else that was stated in the agreement. I don't know why he is saying that I haven't. And the only thing that he is still supposed to get is this check. And like I said, I have been doing the work all this time. I've also had a hip replacement in this time frame.
I appreciate all the problems that are out there and everything, but the court has to enforce orders that say, 90 days got to be done. It's got to be done.
I understand.
And I mean, otherwise you could come in here and say for the next year, you say, what if your private lender doesn't lend and all this kind of stuff.
I only think that I need another 30 days to be able to have this done.
Well, you're 30 days overdue already.
Your Honor, I just wanted the court to be aware that the mortgage person reached out to me. She is actually a colleague of mine. She's Tom Kuiper's wife. She does a good job. I said, look, I will give her an extension. I said, the motion is not even going to be heard for 30 days. So let me know what you can do with 30 days. And I never heard back from the mortgage person. And as the court's indicated, Your Honor, my client, agreed to this with his spouse really back in March. And we just, are asking the court to allow us to sell the house.
There was absolutely nothing that I could do until the divorce was final. I could not apply for any type of loan while I was still married because his income counted as my income. I had to wait until the divorce was final in order to start any proceedings at all.
Okay. Even if you waited till it was final more than 90 days ago.
I know. I am in my third loan process in the last 90 or how many days. I have been working the whole time trying to get this done.
And all I'm saying is I'm not biased to either side. I'm just saying when you agree to it, you have to agree to it. And
I know
the second one today that I've had that somebody says, oh no, I just need more. And I can't.
In mediation, I asked for 6 months.
But it doesn't matter what you ask for in mediation. You agreed to 90 days.
I know.
Cox, when do you want this done by? Are you going to give her? And first of all, she says she's giving you all the tools and stuff like that. Your client was shaking his head. What does he say is still owed?
If you could tell the court, take your time with what you're still missing. Go ahead.
Yeah. So it's been hard communicating with her over things.
I just need a list of what it is.
Okay, the list that I'm down to right now is 3-speed transmission, tires for my Ford truck, gas furnace, electric furnace.
What does that have to do with anything? This says toolbox, tire changer, tools, and sports cards.
And it also says, and anything else that is rightfully mine. We just did not put a full list of things in because we thought we could agree on things together.
And anything else? Is that what's in the judgment? Mr.
Yes.
Yes, Your Honor.
And how am I supposed to determine whatever other stuff is?
In the court papers.
Well,
right here. Defendant's motion, what the papers for today.
I'm asking Mr. Cox right now, how am I supposed to determine what other stuff is there? Am I going to have an evidentiary hearing to determine if she's supposed to give stuff that isn't listed, but maybe should have been given?
We haven't really had a problem agreeing on the list of things yet. I mean, she's been giving me stuff solely, but we didn't ever sit down and put a full list of stuff together. I thought we would be able to figure that out together.
Understand, and I understand it's ridiculous to, list every thimble that there is.
Right.
But at the same time, if you're saying she's saying she's given you everything and you're saying, no, she hasn't. Are there
She knows that
still
I'm
things
supposed
you're
to
working
load
with,
the stuff up last night. and she
Mr.
kicked
Cox,
it
on,
on
ma'am?
me.
Okay, don't interrupt the referee.
Are you maintaining that he's been given everything he's entitled to? Ma'am?
Are you asking
Yes.
me?
Yes, ma'am.
I have given him all of the things listed in the judgment of divorce,
And
besides the check for $30,000.
Is the air compressor on? I mean,
We have discussed other items that he would like, and I have agreed that I would give them to him. But they are all extra items that are not listed in the agreement.
can't believe she's being so
I'm
petty.
asking Mr. Cox for his considered opinion on this.
Yeah, it looks like I'm just reading the paragraph here, if that might be helpful. Except as otherwise provided in this judgment, each party is awarded shall retain his or her own separate personal property, free and clear of any claim of the other. If either party locates any personal property which in all honesty and good faith belongs to the other party, he or she shall promptly notify them and make them available to the other party. Neither party shall damage or discard any item belonging to the other for 3 days, given such written notice. So the problem is, yes, Your Honor, it was more subjective in terms of, an assumption that they had things worked out, but if they didn't, then they should work it
She's
out
saying
together.
she's agreed to give him some stuff and she'll get to it in the next. How long will it take you? You said you've agreed to some of this stuff. Exchange what it is that you agree to, and then if you still think there's a problem, God forbid, Mr. Cox, you'd contact me and say we need an evidentiary hearing to discuss hammers and nails, but we will if we have to. All right.
Sounds good, Your Honor.
All right. What about when do you want the 30,000? I mean, you've given some time. I mean, you want an order that he can list this for sale immediately?
Yeah, that's what we were asking for. My
Well, I know
clients.
that's what you're asking for, but I'm asking you as a practical person, how long do you say you need to have it refinanced, ma'am? And if it's more than 2 weeks, you're not going to get it.
I mean, I said that I needed 30 days. I'm still giving papers to underwriting that they're asking for. I'm waiting to hear, I can't make it go any faster.
And how's Mr. Ellenwood or Mr. Cox supposed to even know that you are working on this as hard as you can? I doubt very much you provided any of the documents to Mr. Cox, because if I'm asking for a favor, I would be giving him every bit of information that I had. See, here's the application I did. Here's this one. Here's that one. So that maybe he would give you time. But if you're not giving him anything, it's just you stating, hey, I'm trying.
I can reach out to my broker and ask her to send to Mr. Cox what the progress of things and where she thinks things are at. My only
Mr.
concern
Cox
is that,
actually talked to your realtor before and gave you some extra time, but then she hasn't gotten back at all.
right, because she was unable to help me and had to send me to a private lender and that's who I'm dealing with now. Because I couldn't get a conventional loan of any kind because I did not have an income to report and I did not have a business established for more than 2 years because Mr. Ellenwood took all of that with him.
That's what happens. It happens in the judgment. And there's a very good chance maybe you are not going to get a loan.
No, I owe less than $15,000 on the house and it's worth over $225,000. I will not have a problem getting this loan with a private lender or using my house as collateral.
Well, but it's taken 4 months and we haven't made any progress.
No, I just started working with them after Lisa Kuiper couldn't help with the situation. She sent me to she told me she talked to like 30 different brokers trying to find somebody that could help me. And finally we found one and they are working on my loan process right now.
It's going to take 30 days.
Mr. Cox, I'd be interested to hear from you as a final statement here.
Your Honor, my client, he's sitting next to me here saying that he doesn't want to agree to 30 days. And I'm sorry that that's where we're at, but that's what he's indicated. We're also asking for my attorney fees. I did attach an affidavit and We are seeking $1,007.
$11.50.
Yes. You know, we're forced to bring this motion and again, I did try to work with the mortgage person and I just have not heard back from her. So
You filed this in court within days of talking to her the first time. That doesn't even make sense.
hey,
He filed it after 90 days, after you did not comply with the order.
No, I'm just saying what he just said, saying that he couldn't cooperate with my mortgage broker. He filed these papers
Contacted
within
the mortgage
days.
broker and she didn't get back. How's he supposed to know anything different? You haven't provided him anything.
I was unaware that he wanted anything provided to him. No one had asked me for
All
that.
he wants is his money and his name off and everything like that. That's all he wants. He doesn't care how you do it or anything.
know.
If I'm asking for a favor from somebody, I am going out of my way to make sure. I'm going to give, who you going to hire to list it, Mr. Cocky?
yeah, we have Aria Wilcox. She is a realtor who's been in the business for about 30 years, and we use her as our main source of listing properties in our divorce situations.
This is not really. I'm going to grant you your attorney's fees because it was not done within the appropriate period of time. I do find that having gone through them, that they are reasonable. I do know Mr. Cox's appropriate hourly rate, if you will, what he would qualify for, the amount of time that he has spent on this, including today's time now, is certainly appropriate. You can get an order for that, the attorney's fees to be paid within 90 days of today's date. I'm just trying to decide whether I give her any more time before, I assume you'd have to contact the realtor and things like that. Otherwise, he'll be allowed to list the house for sale. It's straightforward in the judgment. So I hesitate to give you any more time.
I understand.
And it'd be only out of kindness that I do. I hate to have you lose the house if you, or whatever it is.
That's what he keeps telling me too.
Well, I understand, but there's nothing left to do. You agreed to it and it just is not being done. If it is, if he does not have in his hands the $30,000 in his hands paid to him, I'm going to give a specific date, Mr. Cox.
Yes, sir.
And I'm going beyond, and I shouldn't be doing this basically. And what are we today? The 20th?
Yes, Your Honor.
If you do not have the funds in your hands by the 17th of November, you will be allowed to immediately list the house for sale.
Thank you. Thank you very much.
Your Honor, understanding that will not happen until we learn what happens by November 17th. Can we also make sure that we have the other more specific relief that I've requested, just in terms of making sure I don't have any headaches with the realtor and things like that?
Yeah, what other specific relief do you want?
That my client be allowed to sign the listing agreement and so forth.
Yes.
All right.
And I have one other question. Would I be able to do repairs to the house to try and get more out of the house? And if it sells for more than what it was assessed on for when we agreed on how much money I was going to get out of it, how much she was going to get out of it, would I get, more if I can get more out of the house?
You're getting $30,000. I thought that was the agreement.
That is the agreement.
That is the agreement.
That is the agreement. So
I'm sorry. And I'm going way beyond what I should, giving an extra 30 days, but you can set it all up for the 17th. If you do not have the money in your hands in a cashier's check or something by November 17, by November 18, you can have it listed for sale. And it will be all your ability to do that, sir.
Okay.
thank
And
you.
you will not destroy or do anything to the house to lessen its value, so that it's just going to happen. It's going to happen. Okay. And I'm going beyond where I should, but I don't know. I hate to see somebody lose a place for $30,000. And
Right.
so quite frankly, you are also, in the meantime, you are to provide Mr. Cox with all your refinance information so that he can keep track of it.
Okay.
Mr. Cox, you can prepare an order.
I will, Your Honor. Thank you very much.
Mr. Ellenwood, I almost want to apologize to you for not enforcing it within a shorter period of time. I'm going to give her one last chance, and there will be no other chances. None.
Thank you, Your Honor.
Thank you.
Thank you.
Have a good weekend.
I knew this was going to be a tough day, so I really.
Technology is such a blessing and a
Oh,
curse.
yes, I love it. It's the bane of my existence. But luckily, I have Tracy Dewey here to
Yes.
guide me through everything. This is the matter of Meinke versus Meinke. Both parties present via Zoom. Mr. Meinke, represented by Ms. Solar, Ms. Meinke by Ms. Judd. This is defendant or plaintiff dad's parenting motion, history of substance abuse of mom. We've recently had a hearing where her parenting time was limited. Ms. Solar, I know you're making some other allegations that are doesn't seem to be going good for mom. How much you want to go into it? I'll give you your chance to. I've read both things, but go ahead.
Thank you, Your Honor. I'll try to be brief.
Yes, please.
The allegations in our motion are not misleading or overstated, as the defendant stated in her responses. Her relapses or cancellations of parenting time without notice, and her failure to communicate to the plaintiff her entry into rehab programs or sober living, or when she is hospitalized due to a relapse, has happened time and time again. This is a repeated pattern of behavior. And I know the court, we've been in front of you several times on similar issues. When we were here in July, the court specifically stated to Ms. Meinke that continued issues with relapse, even if they were, one day was not full recovery. This time around, the parenting time supervisor, the plaintiff's own mother, or I'm sorry, the defendant's own mother, approached plaintiff with her concerns, and she stated that she does not believe it to be in the children's best interest to have overnight time right now.
I understand. I find it hard to imagine how her mother would throw her under the bus unless she clearly thought there were problems.
Correct, Your Honor. And there was mention in Ms. Meinke's response that there was allegations that Ms. Borg was somehow coerced and said she wouldn't get to see the kids if she didn't sign the affidavit that she did that, and just patently untrue and did not happen. If anything, Ms. Borg is just fulfilling the role that the court wants her to fulfill as a parenting time supervisor and raise those red flags when she thinks it's needed, and that's exactly what she did here. So these children continue to be deeply impacted by Ms. Meinke's poor decision making. We are asking that the court act swiftly in their best interest by reducing her parenting time to get rid of the overnight time for now. We would be open to an increase of supervised time to include supervised overnights again upon Ms. Meinke's demonstrating that she has full sobriety for an extended period of time and is completely substance abuse and completes a substance abuse and psychological assessment as the court has previously ordered in this matter.
Who's going to supervise her?
So her mother, Ms. Borg, is still willing to supervise, and as far as I know, Ms. Meinke is still open to that. Although I can't speak for her.
All right. And supposing, what if her mother does not want to supervise?
We did confirm with Ms. Borg as recent as yesterday that she is still willing to supervise.
All right. Ms. Judd, you haven't been involved with this case nearly as long as I have, and over again. And I respect your response, but where there's smoke, there's fire. I mean, the idea of her, she admits she screwed up again, only to go for help afterwards, but she screwed up before going for help to begin with. I don't understand this idea that she checked into sober living because her husband had a problem in the past or something like that, was having this. That doesn't make any sense to me. Her mother is the one who's coming through and telling. Her mother has been there for her. Her mother has helped. Her mother continues to supervise. They're just. Go ahead, Ms. Judd. You know where I'm coming from, and you're fighting an uphill battle.
Well, I'm not, frankly, I'm not trying to fight, Your Honor. I looked at the order. She quite literally has 2 days a month. 2 nights a month. She's not asking for more. And I guess the thing that I see that's missing here is that there's actually been exposure to the kids in a matter of years. I'm not trying to excuse the past. I'm not trying to excuse any of this. We had talked while we were waiting, and we agreed to implement the family wizard so the parties could communicate if any changes need to be made. But she's committed to her sobriety. She's happy to take direction from this court. If Mr. Mikey wants to pay for a sober link, she's happy to do that. We can incorporate that into the order as a prerequisite to
I would
reinstate.
be more likely that Miss Meinke would pay for that, not him, because he doesn't have the problem, and she has repeatedly.
Fair. That's fine. And if that's fine, I mean, she would ask that her time be reinstated. She's happy to do a sober link testing schedule if the court wants her to pay for it. That's fine. She has a breathalyzer right now that she purchased that she's happy to utilize upon request. She's happy to share the results before her parenting time. This isn't a situation where she's showing up to her time intoxicated. This is a situation where she's very clearly struggling with substance abuse history. And like I said, I'm not trying to fight here, but she hasn't seen these kids in over a month. She wants to spend time with them. She's not asking for an increase in time from the order that just entered in June. So if we need to implement this sober link, that's fine. But I guess I don't see where her not screwing up in any fashion of any kind is a prerequisite to her seeing her children under any circumstances, including supervised. She's supervised. She's not alone with them, and she's not asking to be.
The supervisor seems to be saying, I don't think it's a good idea for overnights right now.
I guess the problem I have with that too is that Miss Mikey could speak to her father probably having a very different perspective, and her parents are going through a separation, and her father unfortunately can't supervise for the reasons I outlined in the response, but he could certainly be there for part of the time. I don't want to overemphasize here the discord between my client and her mom, but I do have concerns that this is.
I could send her to Journeys instead.
Well, I don't want to do that to the kids. I don't think that makes any sense for anybody, but it sounds like her mom is willing to continue serving as a supervisor if we implement the sober link requirement to confirm her sobriety. If the court's insisting that that be a prerequisite for her enjoying her time, I'm happy to incorporate that into an order. But she's doing the things that she was requested to do. She's very committed to her sobriety. I don't expect perfection given her history, but she's owning up to this. And I hope that goes somewhere with the court.
It does, but it's been, I mean, at some point, everybody always tells me relapse is part of this, but it has happened again and again and again. All right. And at some point you just have to stop.
Right. I get that.
End of story. And I can't keep, I don't know how many chances I give.
Right.
I mean, is one too many? Is 2, 3? Mr. Meinke will tell you, and I've learned through court, he wants her to be sober. He wants her to succeed. Okay. But he also has a responsibility to his kids and a mother who is just still struggling. And she came in and told me what a great job she's doing and stuff like that. But quite frankly, it's been at least, I think, wasn't there another time earlier this year that was oh no, I only did it once and this kind of stuff, and doing it once and once again, I'm not sure how much I mean, I can't figure out why she would have checked in because her husband checked in or something and this kind of stuff. None of it makes any sense. And it makes sense that her mother is doing her best job to supervise this.
Right.
So Ms. Solar, I'll give you a final word. Is there what do you want? You want it to just eliminate the overnight?
Yeah, Your Honor, I think that's the most appropriate thing here. I mean, Mr. Mikey has tried this entire time to ensure that the kids have open communication with their mother, even at times when she's disappeared with her mother's family, and he has done an amazing job of that, better than any other client I've ever had. So, it's that we don't want Miss Mikey to not see her children, but we certainly think that at this time, based on the opinion based on what's happened recently and the opinion of the parenting time supervisor, that the overnight parenting time needs to be terminated for now. Again, we're not saying forever. We're saying for now.
All right. And are you seeking this sober link thing or something?
We'd certainly be open to it. It would help in that
All
time
I'm saying
period.
is, don't make her responsible if you don't really think, because it's an added cost and because her mom's there and everything. If you think her mom's still an adequate supervisor, or if you really think, I'm gonna grant that if you really think that way. But it sounds to me like the mother is kind of a stopgap there. I don't think the mother would have Miss Meinke show up drunk.
I agree. I think, it was indicated that Miss Mikey has a breathalyzer of some sort, instead of paying for SoberLink, because there is a pretty big cost associated with that. If she wants to perhaps just take a breathalyzer upon the beginning of her parenting time, or, outside of the viewing of the children, then I think that we'd be agreeable to that.
How do the kids get to the supervised location?
Currently, most of the time, Ms. Borg picks up the children for the start and end of their time.
All right. And so when is Miss Meinke supposed to take, she should take a breathalyzer and show it to Miss Borg?
Right, at the beginning of her parenting time.
All right. Then there should be no extra cost to that or anything.
Right.
You can do that at the start, show it to your mom. You don't have to do it in front of the kids. You can do it just prior to that, show it to your mom, and that'll be sufficient for that. And what is was the current parenting time?
Right now, I believe
I've got so many of these kids.
Saturday at 10 until Sunday at 6. I don't want to eliminate the overnight and have her just have a Saturday. I mean, like I said, it's twice a month. So I don't want her to have
every other
that
weekend.
That's what I mean. It's every other weekend. If we're eliminating the overnight, I know Ms. Solaire's response or motion requested 2 hours on a Saturday. Would it be okay to do time on both the weekend days, but simply eliminate the overnight if that's the concern? So she continues to have some amount of quality time with the kids.
Borg, is she willing to do that? I mean, I'm gonna eliminate the nights. I'm gonna eliminate the overnight. So it's just a question of whether or not she gets Saturday and Sunday. But Saturday will be from 10 till 7, and Sunday from whatever. Again, a time of 10 o'clock till 5 o'clock on Sunday.
Well, maybe Ms. Solaire and I can communicate together after we rope in Ms. Borg about how this might be able to work, just provided that we have an understanding that there's a quality chunk of time on both of those days.
What time does she end on Sunday, Ms. Solaire?
usually it was 6 p.m.
All right. I'll order 10 o'clock till 6 o'clock on Saturday and Sunday. All right.
Right. And then now that there's two attorneys, Ms. Judd and I can talk to, and if we need to make little adjustments, we can certainly agree to that.
If the two of you can't make little adjustments and figure it out, then I have no hope left in of having attorneys who can cooperate.
We'll get there.
Both of you are very well versed in, you know where I'm going with all this stuff and things
Yep.
like that too.
We'll get there, and I'll have her utilize the breathalyzer, and hopefully we can get this on track and keep it there.
Ms. Meinke, listen to your attorney. You're going to have to give up some stuff, but you're going to have to work back into it. And you're just going to have to do this. All right. Mr. Meinke, I'm going to say to you again, you've done nothing wrong, and you've done the best you can with your kids. And I think you've done the best you can with Ms. Meinke. Hang in there. And
we're okay incorporating the family wizard then into the order.
Yeah, if you guys can do that, that's great.
Yeah,
Perfect.
we did agree to that. Yeah.
All right.
Okay. Sounds
Good luck,
wonderful.
everyone. Thank you.
Thanks.
This is
Have a nice
motion
weekend.
Brought by
Thank you.
Mr. Brown, so that I
Thanks.
can
Bye-bye.
get to it. Mr. Shepherd, I didn't get your response. I got it. It was late and I didn't get a chance to review it, so I'll give you a chance.
I appreciate it, Judge.
This is the defendant father's motion for parenting time enforcement. He doesn't know what school the child's in. Also, he says he has done everything that he can for Hope Services of Muskegon, which last I heard, he didn't want any part of it, but he has now done everything. Let me start there, Mr. Shepherd. Have you now done what you can for supervised parenting time with Hope Services?
Yeah, Judge. So we were under that impression as well. My response indicates Mr. Brown has said before he couldn't afford it or he couldn't get there, keeping in mind this is in Muskegon, Judge. So we were unaware that this was going on. My client did contact them on the 18th. I have a confirmed email this morning that was sent to me indicating that she's successfully registered. Case information has been processed. They're going to put together a schedule. I mean, as soon as she found out about this through his motion, she took those steps. So she's as advertised in this case.
All right. Then that should take care of that. Mr. Brown, make sure that you continue on with the Hope Services of Muskegon, and hopefully you will get your parenting time through there so that we can start developing some type of a track record.
Yes, sir.
Second, Mr. Shepherd, why doesn't he know at least where his child goes to school and stuff like that?
I think it's a good question, Judge. And I say that to you because I get a lot of calls, and this court probably sees this issue a lot. Ms. Francis has sole legal custody, has always had sole legal custody. The problem here isn't the disclosure information in a general sense. The problem is, what is Mr. Brown going to do with it? And this court's aware of Mr. Brown's outbursts in public, where he goes, what
But
he
I've
does.
not seen him go to a school and grab his kid, can be informed that he's not allowed to take his kid and stuff like that. The school can be informed that he, is not to show up there and stuff, but he should have some right to know something about his child. He's been inappropriate in court on several occasions, but he has never stolen the kid or done something like that. And
Your Honor, if I can get a chance real quick, it's just a matter of Ms. Frances not liking what I do with the access to my child's information at the school, where I have developed a relationship with the principal and the guidance counselor and her teachers. And I let the court know that she was tardy 2021, where she was truant, and then 2022, where she was borderline almost truant, and then she moved her schools, and now it's not okay for me to be able to hold her responsible, Your Honor.
Judge, it has nothing to do with Mr. Brown's parenting time complaints. He has no relationship with this child whatsoever.
And
I wonder why that is.
I don't want to go off on a tangent here, okay?
I'll tell you this, Your Honor. Ms. Frances would be happy to tell him where she's attending, because the other allegation is that she's not attending, which isn't true. There's nothing to that. Ms. Frances has been luckily, Ms. Frances has been engaged for this child, because absent that, God knows where she'd be. I'll let Ms. Frances indicate to Mr. Brown where she's attending. And I would ask, Your Honor, if that's what the court's ordering her to do, she'll do it. Yeah. But I would just ask that the court explain to Mr. Brown the expectations of this court, because he has conducted himself appropriately at other times. I can't say he hasn't, but given what I've seen on video of him, and given what I now know in this brains report, we've got to be very cautious about how we proceed moving forward.
Happy about Mr. Brown to know what school his child attends. And I mean, Mr. Brown can make an appropriate contact. I mean, if he wants to contact the principal I don't want to keep him from.
Judge, I'll leave him to do that and leave the school to dealing with whatever happens. If Mr. Brown's appropriate, hey, great. Yes. Right. This has been my client's concern, and I think the court can understand why.
I understand, but I'm operating under the assumption that Mr. Brown will be appropriate with the school. And so once we leave here, you probably have Mr. Brown's email address or something like that.
He's contacted me by email, and I'll call him. I don't care.
However you get the information to him, just get it to him today.
Where she's going to school, correct?
Yes. Yes.
No problem. I'll tell him. I'll do it in writing so that Mr. Brown has it. I'll just give him wherever she's going. I actually don't know. I'll have my client tell me, and I'll pass it on to him. Shannon, do you understand that?
Yes, I do.
All right.
Okay.
Then that information will get to you yet today, sir.
I'll email that. Give me about 10 minutes, Maurice. I'll talk to Shannon.
And then make sure that you continue on with the Hope Service of Muskegon so that we can get time going. Good luck, everybody. That should take care of this.
Shannon, email me where she's going.
Okay, I already did.
Thank you.
Yep.
All right. That one pretty easy. Is it a motion made by father regarding Kenneth? Have you moved to Arizona, ma'am?
Yes, I did. Me and his father made a verbal agreement because I had a job opportunity down here that he would send Kenneth at the beginning of August. As soon as the beginning of August came around, I got all these excuses why he won't send him to the address and he don't want him down here.
No, it wasn't none of that.
Well, I don't know of any agreement that says the kid can move down there at all. I mean, you're telling me
No. We made a verbal agreement. It wasn't through the courts.
Well, verbal agreement's worth what the paper that is written on. Mr. McBride, what are you seeking then?
No, me and her, we discussed it. I asked her, all she had to do was just send me an address to where Kenneth will be moving. Yet I still haven't got an address. I keep getting a runaround. They keep telling me I don't need to know where they stay, which is not true, because if I'm sending my son out of state where he don't want to go, I at least need to know where, he's laying his head and what's going on with him. And yet I'm not getting any of that information, but I just keep getting told that I need to send him here and I need to send him there. He's in school now. He's doing good in school here. He really like it. I really like it for y'all to talk to him yourself instead of going through me and Tamika, because I feel it's best in his interest what he wants to do, not in our interest, because neither one of us can even come up to a neutral agreement or, what I'm saying, or just be casual about anything, because it's always got to end up to an argument. Yes, it does.
All right, well, this is between the parents, and if I have to have a hearing, I will speak to the son only as it is required by the law. All right, I want this to battle between the mother and the father. And ma'am, I don't know what to tell you other than if Mr. McBride is not willing to send him down there, there's no binding agreement that I can follow. And you'll have to make a motion to the court to move your son down there, and I'll have to have an evidentiary hearing to determine if it's appropriate or not.
And I can do that, but I also have text messages and screenshots of him agreeing to send my son down here. And then out of nowhere, when it's time to send him, he's sending me all these text messages saying where he live. And I told him when I first moved down here, I was living with somebody else. I would not send him the address to where I was living with another person.
Why would
my own
a father send a son to someplace that he doesn't know where you're living and you're living with somebody else?
No, I have my own place now, and I offered to send him the address. When I offered to send him the address, he still refused to send him.
Well, did you send him your address?
No, yes, I did. Yes, I did. I sent it to my son. Yes, I did. Yes, I did. I sent it to Kenneth.
Did you send it to the father? This is between you and the father.
I can't send anything to the father because no matter what I send to the father, he won't respond to, or it's always an argument about it.
It doesn't say that he's gonna, it says you send it to him. He doesn't, ma'am, I'm just gonna tell you, there is nothing here that if he doesn't send the child, then you gotta make a motion. I'll end up having an evidentiary hearing on whether you can move there or not.
Yeah,
It'll be in March.
Then you said in March?
It'll probably be, because I don't have hearing dates for months. I'm trying to get as many in. If Mr. McBride wishes to send the child there and stuff like that, and you wish to talk about it and send him the address and where everything is, and when he's gonna get to see his son, then
I sent the address and we made a verbal agreement on when he can see him, and he's agreed to that. And I have all the proof through messages.
You have to put it in a court order.
Okay, yep, I will do. I will do.
And if you do not stipulate to the court order, then I have to have a hearing. Because I can't force him to agree, nor do I intend to force him to agree.
So the fact that he agreed and he's had people run off with my child isn't an issue. He's had females take my child and run.
Agree to something, that's fine. If you can't, then I gotta have a hearing.
I'll file another hearing. That's fine. March is fine with me. Yeah. Okay.
All right. Anything else, Mr. McBride?
No, sir. No.
I want my son for Christmas break.
Okay. That's fine with me.
Work on it.
And do you mind when I ask for a favor?
Right. You'll either have to file a motion for it or you'll have to work on it. I don't know what is going to occur. It's unlikely that I don't like sending a kid to some place that isn't allowed to go to. So I'll have to deal with it at the time. So at this point, sir, you asked for parenting time.
I'm not agreeing with his parenting time at all because he's never lived with his father. His father doesn't even have a stable home of his own. He's living on couch to couch.
I have a stable home that I'm staying in.
I have a stable home and a lease in my name. He does not.
Well, at this point, you're not allowed to take your son out of state without my permission or without an agreement of the two of you. So I don't know what parenting time you want. I don't know what anything. She lives someplace else and not in Michigan, and she's going to have to try and get it. Until then, I got to modify parenting time so that the parties shall have alternate holidays, birthday, Mother's Day.
So will I be able to get him for his birthday? Because his birthday is coming up soon.
So you can have him every year on his birthday.
That's not the agreement we're coming to now, so that's pointless.
Work it out or I'll have to.
I'd rather for you, sir, because we're not gonna be able to work it out. She's too stubborn to work anything out.
Well, she's gonna have to file a motion to change domicile then.
No, I'm going to file them today.
Okay.
Whatever. Good luck, everybody. Thank you. She's not connected. Do you have some type of guardianship or something over these kids?
I did have guardianship over them. It was terminated on 9/22.
Just last month then?
Yeah. What she's trying to do is get the child support that I was getting for the oldest child transferred back to her because it was transferred to me when I had guardianship. And then I established in a child support order with the father of the younger two. But I was told by friend of the court that can't be transferred or something. I'm not quite sure. He owes me, he's in arrears with me. So they said something about like assigning her a different docket number. I don't know what that procedure is.
She's got to file something for child support from the father. I can't just, in this particular case, you and her, the fathers aren't even a part of this case. I mean, this is a child support order from her to you. Okay.
Yeah, what she wants to happen is the oldest child's father, she had already established that before I took guardianship.
I understand, but she needs to file under a case that has to do with the fathers. The fathers aren't even notified of this.
She went to legal aid. I don't know what she filed.
I have no idea, but to the best of my knowledge, she hasn't filed. I mean, the fathers are not here. The father's not here to even, I mean, she filed it in a case that's you and her. It has nothing to do with the fathers. Okay.
Yeah. Well, I think she got confused because I'm the one that was getting the support.
Is she ever gonna log in?
I thought she was.
No, she has a matter of
I can tell her to log in.
Cotto versus Gill. There's a motion brought by Ms. Gill regarding child support, but it's in a case that doesn't even have to do with the father that she's seeking to get child support from. It deals with the guardian, which is her mother, and the daughter in child support payments there and stuff. The fathers are not even notified.
There is, I ended up getting 2 or 4 weeks worth of payments, which is 2 payments combined.
I
That's
don't know
what she would
happened in
like.
your case. Ms. Gill, can you hear me? Both parties are present via Zoom. I've spoken briefly to Ms. Cotto. Ms. Gill, the bottom line is the fathers didn't even get notice of this. There's nothing for me to order the father to have paid child support in a case between you and your mother. You're gonna have to file it appropriately because I'm not going to do anything in this case. The father isn't even notified of this hearing. So whatever you have to do is whatever you have to do, but I'm going to deny this because the fathers aren't even notified to be here.
I think they had to.
Well, how would I have a hearing about child support for them with them not even having a chance to respond? You think you just get to come in and say, hey, do this? No, to answer my question, no, you can't. So you'll have to file it in whatever is appropriate. This is a case between you and your mom, has nothing to do with you and the father. So you're gonna have to figure out something else because it's not appropriate. So I'm gonna deny your motion. Thank you. We're adjourned. Thank you.
Thank you.
Mr. Hardley, can you hear me?
Yes, sir.
All right, I can see you now too. This is case of Colvin versus Hardley. Motion filed by father regarding custody for, I believe it is Promise, who is 17 years old.
Yes, sir.
They're trying to change custody to you. Is that correct?
Yeah, she lives with me, and it'll be a lot easier so I can get her back in school and stuff.
How did you get mother notice of this?
She's been just staying with me since March.
How did you get her mother, the plaintiff in this case?
Well, I haven't talked. I talked to her about a month ago. I haven't, but I just got my daughter since I had my place.
In order for me to have something on this, you have to serve the mother a copy of this motion.
Yeah, they had her address down at friend of the court. I think they sent it off to her because I don't know what her address is.
And you dropped that off down there a while ago?
Yeah, yep.
Is there any way to check? We'll check and see.
She lives in Tennessee somewhere now.
We have no proof of service that they served her.
Yeah, they were supposed to mail it because, like, her address, I didn't have her address.
Well, all I'm saying is we don't have a proof of service to show that it was sent to her, whether a friend of the court screwed up or whatever. And so here's the reality is I can't do it until I at least know that she has been served or an attempt has been made to serve her. I can't hear this. We can adjourn it, but the reality is, even if it goes to change custody, unless you can get an agreement from the mother, I'm going to have to, the best I do is set an evidentiary hearing, which will be sometime in March or April, to try and change custody. And then you'll have to come in and show why I should change custody. It's getting pretty close to the point where your daughter will be 18 by the time we change custody, but that's what I can do. And that's only after you renotice this. I have to have proof of service on mother before I can proceed to even hear this motion. Right, so you better check with the friend of the court. It appears that everything is correct. I'm not denying anything you're saying. I mean, the last UCSO uniform child support order showed her having 0 overnights. So I assume that obviously the child's living with you, but I can't even hear this until I know that she's been served appropriately.
Okay.
You'll have to go to the friend of the court and make sure that you get her the documents and see what you can do to send them to her. All right.
Okay. All right. Appreciate it.
And when it is, you can renotice it as long as she's got at least 10 days notice. All right.
Okay. All right. Okay. All right. All right. Thank you. Yeah. Thank you. Sir. Yeah. Have a good one.
You two are present via Zoom. This is the first several motions that were brought. Ms. Lopez has asked for, first of all, basically the child to be able to get a passport. Do you disagree with that, sir? Or will you cooperate to get a passport, or do I need to order it? Now you see why it takes us all morning to do this kind of stuff and why you have to continue to wait, because all these people have problems. He appears to be frozen. Ma'am, can you hear me all right?
Yeah, I can hear you.
Yes, I can. Much better.
Okay, sounds good.
All right. I've already introduced the case. First motion is mom wants the child who looks like is what, about 7, to get a passport. Are you fighting that?
Yeah, I am.
Why?
Because I want him to spend Christmas with me this year.
I didn't allow him to move. Or go anywhere. I just said he could get a passport.
Oh yeah, I allow that.
He can't even go anywhere until he gets a passport. Ma'am, does your son have a passport?
No.
Then Mr. Lopez, you'll cooperate and sign whatever is necessary to get a passport. Is that correct?
Yeah, of course.
All right, ma'am, then that settles that issue. All right. As far as travel to Mexico, if you're asking, first of all, you'd have to ask for specific dates and times, and I can assure you that if you're not going, that the child isn't going. It's not just going to go there with grandma. It would go with you. Are you going along on that trip?
No, I'm not.
All right. Well, the child should stay here with you and or father. So you can get a passport, but I don't believe I'm going to allow it. You can make a motion at a time when you give me specifics, because I don't know anything specific about such a trip. I mean, I don't know when it would be. I don't know how long it would be. I don't know where it would be that you're going to specifically, but it's unlikely that I'm just going to send the child with the grandparents as opposed to with you. The child should spend time with you and Mr. Lopez. So I'll grant the order for a passport and at least at this point, deny transportation to Mexico. The next issues that I have in front of me, both of you have filed for custody. Ma'am, you have physical custody. You understand that, don't you?
Yes.
So why are you asking for custody?
I want full custody. I want to be able to make choices like the passport thing, if anything comes down to like needing medical
Well,
necessity
then
for
we'll
him.
have to have an evidentiary hearing about that one.
Okay.
Sir, what's your response?
I oppose to that. I want to be able to have him more overnights with me.
Well,
We've never had that, any orders for that.
Oh, you're asking for 50-50, which would be a change of custody, and that would need to be before I'd have a hearing on change of physical custody. I need for you to meet Vadvarka, which is a standard that says there's a change of circumstance or proper cause to allow for that. You can't just come in and say, hey, I want 50%, because what parenting time or anything goes on now?
None.
Well, then what we need more than anything is we need to get a parenting time thing out there.
We did try parenting time. We've tried parenting time, and he comes and goes when he wants. He doesn't show up after years or months. So that's why I don't. That's why. Yeah.
Well, we're gonna have to either start setting sometime where he's got to be there, or else. I mean, you can't just deny him parenting time and that kind of stuff. We're gonna have to set some kind of a parenting time. I mean, is there any reason you shouldn't visit every other weekend or something?
I did allow him every weekend. Actually, he came every weekend for a long time, and then he has certain situations that pop up and decides not to come, or tells me the day of that he's not coming, and then he disappears for months and then comes back again doing the same thing.
So what are you suggesting that he get? What are you suggesting?
I don't want to keep allowing him to come in and out anymore, because my son is now 7, and this most recent time it brought him to tears not seeing his dad. And now at this point, it's been so long he doesn't even remember his dad. I've tried reaching out, and I've even reached out several times to him. I'm the one that has reached out to him several times.
Hey, if he wants parenting time, are you saying I shouldn't give him any?
I'm saying no, because he's gonna do it again, and I don't trust him.
That's not going to happen. I can assure you. I'm going to send this to the friend of the court for parenting time and legal custody. We'll send it to you. Do both of you work?
Yes.
The $150 cost for each of you to send it to there. You'll be notified. You'll have to pay it. If you don't pay it, it's not going to go good for you. I will send it to the friend of the court for legal custody and parenting time.
May I say something?
Yes.
Can we just come to an agreement that as of now I can have my son every other weekend from Friday to
No.
Sunday?
You can come
Because
to
it
an
doesn't
agreement,
happen.
but he's not going to. But I can tell you, ma'am, that he's going to get that kind of time.
That's fine. I'd rather it go through the court first. That way
you guys
going through
can
the
see
court.
for, yeah, that way it can be at least scheduled. And if he doesn't meet
Right.
it, then we can move forward with that.
Pending the front of the court investigation, I'm gonna order that he be allowed parenting time with his son every other weekend from Friday at 6 till Sunday at 6.
Perfect.
Is that,
Hey, can I please mention, so the reasons why I need to know ahead of time when he's coming. He keeps saying he's gonna come and then he
it will
doesn't
be
show up.
Friday at 6, and he'll return the child Sunday at 6.
Sounds good.
And if he
And
doesn't
he-
show up by 6:15 or 6:20, he's gonna lose it.
Sounds good.
You know where she lives?
Of course. That wouldn't be
I
no
don't
problem.
know where he lives. I don't know who he lives with. I've never met any. I don't even know where he lives now. His address is not that Brown Street. He's moved.
Who do
I've
you live
requested
with,
to at
sir?
least let me see.
I live
because-
with my current partner now. I have a baby girl. I live now in a different address. And the reason why that address is not known is because if you see from the motion that I filed, I have certain screenshots where she has threatened and said a lot of things. She showed up to my parents' house where
I don't care. It's time that you two are gonna be adults and parents. And if you don't start acting like adults and parents, I'm gonna take some affirmative actions against somebody. You will tell her, I'm not gonna have you tell her right this minute because we're on YouTube and not everybody needs to know your address. But after you get off here, do you know how to text her or something like that?
Yeah, of course. I can do that. I'll text her my address and she'll know where I live at.
Text her your address and ma'am, you'll know where the
Yeah.
child's going.
Yeah, but he doesn't, I don't feel comfortable with my son spending the nights. He hasn't seen him in so long. He doesn't, my son still sleeps with me because he's
My
scared.
son just seen me
So much more
literally 3
to
months
it
ago.
than just being like, here you go. He
My
hasn't
son has
seen
seen me
you.
My son just seen me 2 months ago. We were just seeing each other.
He hasn't seen you in 2 months. That's a lie.
When was the last?
More than that.
Well, who the heck's lying here?
I don't remember when was the last time we seen him, but we've reached out to him. I've tried to reach out. I've told him he can spend the nights as long as you tell me where you live and how you live, because he has his own room at my house and he comes over here and he
He
sleeps.
tell
with
you
me.
where he lives. He's with his significant other and has another baby there. It seems like he's reasonable and is not going to feed the child to the dogs or something like that. It seems like he's going to be reasonable. Sir, you will let her know where you live and something about where you live, okay?
Of course. Yeah, of course. She can come and see the place.
All
Like
right,
I have no
he's
issue.
told you can come over and see the place, all right?
That's all I wanted.
And
That's all I
everybody
wanted.
will act as an adult, all right?
Agreed.
All right, so he will tell you after we get off of Zoom here, you will contact her and say where you live. And if you want to set up an appointment to go over to see that, that's fine, okay? But,
Yep.
but don't get into a fight with his significant other, just look at the place, all right?
That's
Just-
never gonna happen.
I'm just telling you, because.
Yeah, I know. I'm not
because
that type of person. He's claiming me to
Well,
be.
it's just the two of you are not acting particularly adult on here, and so I'm just making sure that you do. And then as long as that place is appropriate, he'll start not this Friday, but next Friday.
I understand. I'm just frustrated. It's been a very long time where he's been in and out, and I just don't think it's fair that, I think it's fair that we're gonna give him another chance, but I just hope that he actually sticks to it this time.
Ma'am, if he doesn't, you bring a motion in here, sir. It's not gonna ever work when you come and go out of your son's life. It's
No, I
either-
know.
You're either gonna be in it or out of it. All right, so let's hope this works. We'll also refer it to the friend of the court. Good luck, everybody. We'll get an order out to you so that it will be next Friday will be the first parenting time. And in the meantime, Mr. Lopez, you will text her your number and you will welcome her into your home for a short visit.
Of course.
Can that be supervised?
Can what be supervised?
The short visit? Do I have to set that up with someone?
You have to set that up. You go over to see his house.
And I just don't want there to be problems. So you mentioned that maybe we can set up a time to go visit together.
Who's together? I'm
I
not
don't
gonna
know.
pick you.
If you send not you, but if you send anyone with.
How am I gonna pick somebody to send? What? Take your mom.
Sorry, I
with
must
you.
have misheard you. I thought you said
Take
that
your
we
mom
didn't
with
have
you or
someone go with
something
me.
if you want to.
Okay, that's what you meant. Got it.
All right, and just be adult about it.
Yeah, of
Both of
course.
you.
That's fine.
All right. We're gonna start this going and we're gonna get it going with your son and see what happens. Mr. Lopez, you want the time, you're gonna be given a chance to do it. If you do not act as an adult when she comes over or she does not, I'm sure I'll have another motion and the person, you both have phones, all right? If
Yes.
somebody's acting up, you can film the other person and show it to me and then it will not go good for that person. Come on.
Yeah.
One thing I did just want to mention was when he has not came before, I have offered to drop my son off and he says no. When that happens, what do I do?
Ma'am, I'm not gonna go through everything and micromanage your relationship. If he doesn't want to show up, he doesn't want to show up, and then you'll.
But does
you're
that
gonna
give me a
come in
good
and
reason
say,
to come in?
What?
Is that an okay reason to come in?
like to complain about, or am I just like wrong in saying I have to
You
deal with
can
it?
file a complaint with a friend of the court if he doesn't follow the order.
Okay.
All right, good luck, everybody. We'll
Thank
get
you.
more to you. Thank you. Defendant father's
Thank you.
custody motion wants week on, week off. The only real order that we have for physical custody was in the judgment of support. Mom, the plaintiff was given custody. Sir, your request for 50% is you got to meet certain standards like Vadvarka, which you haven't met at all to even have a hearing for that. What is ma'am, what's your position on this?
I would rather give it some more time. I wasn't even notified actually of this motion at all until I got the Zoom from you guys on Wednesday.
Sir, did you send her this motion?
Yes, I did. I sent it to one. And her phone number is on the same piece of paper where the address is.
Well, she's here. And all you're really asking for is 50-50, but I can't give you.
Well, the reason that, sir, the reason I'm asking that is because, like, unofficially, we were doing that for quite some time. We were doing week on, week off. And then August of this year, she just stopped. And I never really understood why we stopped doing the week on, week off that we were doing. And then I went to the court and everything. And I didn't know I needed to do more. If I would have needed to know I needed to do more paperwork, I would have for sure done that.
Well, I understand, but I mean, I'm just a hearing officer here. I can't give you advice on what to do.
Okay, so
ma'am, was it week on, week off until September of this year or something?
It was for a couple of months, but
for a year.
For the most part, I have been the parent that's been the responsible, stable parent.
Sir, I went to prison for 2 years. I got out of prison. I've been stable. I'm working like full time. I have an excellent job.
3 years. You've only had a stable job since
I'm talking right now.
Ma'am, don't interrupt them.
And the thing is like when I asked her for like custody and stuff like last night, she called me and said, can we reschedule the appointment tomorrow? Because I didn't get anything about it. And on top of that, she's, like a big reason why I want to do this week by week is because of the comments that I get from her when like she was saying yesterday, well, why don't we go back? Why don't we do every other weekend like we have been, and then you can have her here and there throughout. But when I ask, or even when our daughter asks her to come so if I say, hey, can Isabella come and see me on Wednesday? Or if Isabella says, can I stay a couple more days with dad? It's always no. Everything. Then it will be, I'm a narcissist. I'm a sick person. I need help. She feels sorry for the girl I'm dating. All these things are said to me when I ask about seeing our daughter. And that's why I want to go through the court system so that it's legitimate, that it's in stone, that basically I don't have to call and say, hey, may I please have my daughter? Like this weekend, my daughter and me are going out of town. And it's like she tries to belittle me all the time, but I'm taking my daughter out of town this weekend for something. I've paid for her softball. I do things, on a regular basis with our daughter. And until, like I said, until September, more than a couple months, we verbally had the 50-50. And then and I've even rescheduled my work schedule to fit going back to the 50-50 type thing. So that's what I got to say about it.
All right.
That's why I'm
hear
doing
from you, Miss Murray. What have you got to say?
It's only been a couple of months, and in August is when I stopped it because he tried to put me in jail over false accusations, and there was a no contact order. So yes, when he did ask to have her during the week, I said no because we were in a no contact order. Got that resolved.
Do you have a parenting time order at all?
No. He hasn't been out of prison long enough to get one.
I've been out of prison for 2.5 years.
2 years.
When I went to who cares all that stuff you're saying? That's all the stuff you say that's so rude that has nothing to do with me being the good parent that I am.
And I'm being interrupted now.
I did all that. Like if I would have known I had to do anything more, I would have done more. Like I feel like now I just did this and it's like a waste of my time and a waste for my daughter.
As usual, I'm not allowed to talk. This is what happens. I got interrupted and that's okay.
You guys done?
Yes, sir. Thank you.
All right. The law calls for, she has custody, physical custody. There's nothing about legal custody. In order to change custody, you need proper cause or change of circumstance. It's not me making it up. It's in a case called Vidvarka to change it. I don't know what you guys have been doing. You've done some week on, week off. You've done some, I don't know what you did before that, whether it was a weekend, every other weekend or what.
It's been week on, week off for so long. And the thing is we were together before I went to prison. I got out, we weren't together. There's a lot of like bitterness towards me for that. And I'm also dating somebody else, and that's bitterness. So there's a lot of these things.
You've been out for 2 years, so you guys don't exactly get along. And what have you been doing for the 2 years since you got out?
I'm working full time.
No. I'm sure you're a good father. I'm not,
sorry.
that has nothing to do. I'm not going to say you're anything other than a good father. I have to follow the law. Okay.
Right.
All right. And ma'am, you feel that I mean, at a minimum, what should he get as far as parenting time? Just to begin with here.
I've been giving him every other weekend, and I'm willing to let him have her here and there. I just don't feel like he's responsible enough.
That's not going to be really good. If I give him every other weekend, Friday at 5 till Sunday at 5, and you say I'll give him other time, but then he's got to contact you, and whether or not you decide to do it and stuff like that, I don't know that that's going to work out great.
That's not going to work. And all these things about me not being responsible, all that stuff is like
I'm not finding that. I'm not finding that. Stop. I'm not finding that you're anything. I just have to follow the law. I don't believe you're a bad father. You may have had some difficulties in the past, but it's a couple of years ago. I'm assuming you got out and completed parole or whatever.
I'm going to get off tether right now after this meeting. I had no violations.
Oh, that's great. I'm not finding anything. I'm trying to work something out where, at a minimum, you get something, and I'll look at something farther down the road. Ma'am, every other weekend, starting this weekend from Friday at 5 till Sunday at what time?
She goes to bed at 9, so anytime before 9.
8 o'clock.
Works.
Friday at 5 till, all right.
Sir, and I need it to be this weekend that I have her, because we've already got plans.
I've already said that starts this weekend.
Yeah, you have her this weekend.
Okay. So Sunday at 8. I got that taken care of. In addition, I believe, do you guys live anywhere near each other?
Right by each other.
4 miles apart.
All right. So in addition, he'll see his daughter every, how late do you work, sir?
Oh, let's see. I work till 7:30 in the evening.
No. Well, I was going to give you every Wednesday from, 5 o'clock till Thursday morning when you can take her to school, but that's not going to work if you don't get home till 8 o'clock.
Right. And that's why I was shifting for something different, to fit both our schedules and make allow us all to be happy.
And that, who would she be with while you're at work every day until then?
Same thing as always. My
I'm not going to give him that Wednesday night because I'm not going to send her over there to sit there for 5 o'clock till 8 o'clock when Dad gets home and then go to bed.
Right. I understand that.
All right. So
I can't. We can't do every week. I mean, it's okay. I'll ride with this. And so, what's the next step? Because this is exactly what we were doing before. I didn't want to come to court to do exactly what we were doing.
Well, but we got to get an order because otherwise you guys aren't agreeing well enough. That
what kind of order do I need to get? Well, she's never. Well, what kind of order do I need to get? Because I got to do this again, and I'm going to have to do it again and again and again and again and again. So I want to be able to just get it taken care of, like I thought I would today.
I'm not sure that you can get 50-50 based on you got to have proper cause or change of circumstance to get it.
The proper cause is that she was doing 50-50 with me for a long time. And then one day she wakes up and just wants to stop because she feels like it. And that's how it works. So the way that it works
relax,
is
relax. Let me
I am, sir. I've been dealing with this for a while.
Stop.
Okay.
You got to just let me deal with this. All right.
Yes, sir.
Ma'am, it does appear that at least for some period of time, for a couple or more months, there was what I would consider to be proper cause or change of circumstance because he was having the child week on, week off. I don't know how long that lasted and whatever. Therefore, I am going to send this, first of all, every other weekend, Friday at 5 to Sunday at 8, commencing this weekend. After that, I'm going to send this to the friend of the court because I believe there is proper cause or change of circumstance for them to look at custody. You don't have a legal custody order, so I'm going to send it for both legal and physical. All right.
Okay,
we'll find out what the friend of the court has to say. You're going to have to take some time and go there.
That's fine.
You work, ma'am. Do you work?
Yes, I work third shift.
Well, because it costs $150 from each of you to go to the friend of the court. I'm assuming you can pay that.
Yes, that's okay.
No, I can't. I've got bills I have to pay, like rent and all that. I don't have
so
the
does
money
he.
for that.
So
He
does he.
lives with his parents. He
I
does
pay
not.
my bills. You know, this is the stuff that I go through, sir, where she tries to manipulate
Sir,
and put all these
let
things
me,
that
handle
don't
this, 'cause
matter.
I still got more cases to do, and I'm
Yes,
doing the best I can here.
I
Just
appreciate that.
relax, all right? Sir, if you can pay the 150, I'll waive both of your fees, all right? Neither of you has to pay.
Okay,
right?
thank you.
But you're going to get a notice from the friend of the court. You're gonna have to follow the friend of the court. They're gonna ask you for things. They're gonna want to interview you, things like that. You're gonna have to be on your best behavior and go through this, all right? They
Yes,
will
sir.
make a recommendation at the end of it. We'll see what they have to say. If you don't like it, you can object to it, and I'll end up having a hearing. It may take
Okay.
a little bit of while, but you got to just do this one step at a time.
All right, I thought this was the first step that I needed to do. Thank you, and I'll
It
do
really
that.
was, I'm just finding that there's a proper cause or change of circumstance. It is a first step you have to take.
Okay,
But I can't just give you 50-50 right now.
okay.
So
All right.
it's either that or an evidentiary hearing, and I'm sending it to the FOC. Please cooperate, both of you with them, and we'll see what the FOC says. All
All
right,
right.
but
Yeah,
I will issue the order of every other weekend right now. Good luck.
All right, thank you, sir.
This is what happened. The plaintiff
Goodbye.
mom's request
Thank
for a
you.
temporary order. You said in your motion that he was in jail, facing DV and assault intent to do great bodily harm. Apparently he's not.
He's no longer in jail. He was released, I believe, on the 4th. And then this last Tuesday, he had a hearing and he took a plea deal for a domestic violence charge. And then they ended up dropping the assault with intent to do great bodily harm.
Did he plead guilty in a district court or something?
I do believe so, yes.
What court, do you know?
I'm pretty sure it was the 61st district.
Right? And was the victim of that you?
Yes.
All right. And you're seeking a temporary order, at least regarding Apollo, is that correct?
Yes, sir.
What kind of temporary order are you seeking?
I don't want to prohibit him from being a dad. I just don't feel comfortable with him having my son unsupervised as it is right now, with everything that happened. The Thursday before he went to jail, there was a confrontation. It was not nearly as bad as the one that happened on the 2nd. And I didn't call the cops on him, but he headbutted me and my son was sitting on my lap. And I did send the audio recording of that to the police for the case last time.
And do you think he's really going to hurt your child?
Yes.
Sounds like why would he hurt your child?
Before he said that he would pick my son up and throw him on the bed, he has very bad anger issues and he has very little patience.
What about like a supervisor, like his parents or something?
I would be completely okay with his mother being the supervisor.
Do you think she will be?
Since the 2nd, she reached out to me that first Saturday of this month and asked if she could have the baby over there with him so he could see Nathan. And I agreed. She picked him up at 8:30 in the morning, and then we met again at 3 in the afternoon so she could bring him back, and it went fine. She seemed to do fine with that. I don't see why she would have
Then what kind of, I'm willing to give you temporary legal and physical custody. It's temporary because that's all I can do right now.
Yes.
And with parenting time for him, tell me what you think is appropriate. Every Saturday from 10 till 2, as long as it is supervised by his mother.
That's perfectly fine with me. Even if he wanted like a Saturday, Sunday, or like a weekend, as long as he was going to be at his mom's, I would be okay with that as long as she was there.
All right. You want me to give him Saturday at 10 o'clock till Sunday at 5 o'clock every other weekend?
That sounds perfect to me.
Saturday, 10 a.m. to Sunday at 5. You'll be responsible. Make sure that you understand that, talk to the mother and say that, okay, that she has to be there to supervise.
Okay.
Right? If she can't leave the child with dad and go off to the store, okay? As long as she is there supervising, he can have the child. If not, then, you can make a motion to the court if she's not there supervising. Then I'll stop parenting time. All right. So we'll make sure that she is the supervisor. Saturdays, 10 a.m. to Sundays at 5 p.m. It'll start next weekend.
Okay.
You want to drop the child off and pick the child up? It would be just as easy, I think.
I can do that.
All right. We'll refer it to the friend of the court for child support.
Okay.
This is all temporary, okay? You'll have to figure stuff out as it goes on and hopefully make something more permanent. All right? Good luck. Thank you. Take care. Sorry you had to wait so long, but I'm doing as fast as I can. At Goodra.
I appreciate it.
Both parties present via Zoom. This is plaintiff mother's motion regarding parenting time, wants supervised parenting time. She isn't sure where the father lives anymore and is saying kind of some odd stuff to her. Like the end is near and all this kind of stuff. There was a final custody order in this case back in 2017, gave physical custody to mom, parenting time to dad every other weekend and Wednesdays and Thursdays. Since then, father's been to prison, got out, I don't know when. And she would like to change the parenting time order. Does that pretty much say what you want, ma'am?
Yes, correct, Your Honor.
All right, what's your response, sir? Wherever you are.
Yeah, I didn't hear the beginning, so I'm not really quite sure what
Wait,
the parenting
where
time
are
is.
you? I mean, how about me being able to see you and you standing still for a minute?
I can't hear you, sir. I'm putting the phone up to my ear.
Well, then get a better connection.
It's not a connection, it's the volume, sir.
Well, turn your volume up.
It's all the way up. It's not very loud.
Well, every time I talk, you answer me, so I hear it. They must hear me. What's your response to the motion?
I didn't hear what the details of the motion were.
You got the motion. What?
I didn't get the motion because it was returned to sender 3 or 4 times. I wasn't able to even open it up.
How was it returned to sender, ma'am?
I never received the packet back.
How do you know it was returned to sender if you didn't?
Because I called the FOC and they told me that was I kept calling them and asking them, when this motion was gonna come in the mail, and they said they sent it out, and then I kept calling and they said, they sent it back to us, and it said that the address was
How would you know there was a motion? Did mom tell you? Did Miss Ventra?
No, I called and I just checked in.
You called and just called the friend of the court and said, hey, do I have any motions against me?
Well, we had a discrepancy about the parenting time, and I kind of had assumed that it was heading in this direction, sir. It wasn't just a wild guess.
She's asking for supervised parenting time. What's your response?
I think that's ridiculous. I'm not going to agree to that at all.
Didn't ask you to. She's asking me to order it.
I don't think that's necessary. I have nothing on me, or I have done nothing wrong, and that would result in any sort of,
When was the last time you saw your child?
Yesterday.
Your Honor, he saw him for a couple hours or for a couple minutes. And before that, it was a week or 2 ago.
Did you send the child with him?
Yesterday he went to my mom's house to see him for a couple minutes. And then last week he said
he was sick, so I couldn't take him. That's the only reason I didn't take him.
Let me get an answer from her before I get something from you. Go ahead, ma'am.
Yeah, he said that he was sick last week, so that's why he couldn't pick him up. So it's been about 2 weeks since he's picked him up since.
And where's he been visiting with the child since then?
That's the thing. I don't know. When I took him last time,
Sir, she put the tracker on him. It's an Apple Air thing.
When I want to hear from you, I will ask you. I'm getting her side first, and then I'll get your side.
Okay, thank you.
Go ahead, ma'am.
I'm not sure. He sometimes comes with his sister, and they stay at his house. The last time I had to take him to a hotel that he was staying at in Coopersville. But when I asked him the other day where he was staying at, he told me that he didn't have to tell me. When I went to the FD to file this motion, I told him that I didn't know where he lived. When I looked his address up, it told me that he lived in Mel Trotter. So they told me to go to the second floor and to look up to ask him for the last address that he lived at, which was the Fillmore address, which is the address that we lived at before he went into jail or prison. So I don't know where he's staying at. I don't know where he's taking him at. My son tells me that when he goes with him, they're either at the park or at a pool or at his aunt's house or his uncle's house or another uncle's house.
Sir, where do you live?
Right now, I'm currently staying with a friend. Again, it's just kind of been trying to figure out. I'm supposed to be leaving to Texas in a couple of days here because I just got a job offer out there. So I've been trying to wait out till I heard back from that, and that's kind of
So then you're headed to Texas?
Yeah, but it will be just for 2 weeks on, 2 weeks off because I'll be commuting back and forth. So.
And where are you going to live?
I live on well, it's an oil field position, so we live on the rig, and then wherever location is, we live there for 14 days and then come back. So
I need some place where your son is gonna visit that's a stable, not just at a friend's house somewhere.
No, I understand that. Yep, that's completely acceptable. But it hasn't been like I primarily, take him as much as I can, but we're usually out and about just because I know he's cooped up in the house all week at his mom's. I just figured let's go do stuff, and it's really usually not all that bad. But I mean, she sounds like she's pretty concerned. So if she wants to sounds like she wants to take him right away from me. If that's her goal, I don't know why it would be her goal to take him from me, but I guess that's up to you, sir. I mean, quite frankly, I don't see on paper what I'm doing wrong, other than it's a little unstable with the finances and with the.
You're a little unstable with where you're taking your child and stuff. You don't take a
all due
child
respect,
and just kind of go and have a place here and a place there. I don't have a problem with you visiting with your child, but needs to have something. And now if you're going to be gone for 2 weeks and back for 2 weeks, and what are you going to do? I mean, how long is it going to take you to drive back and forth? When are you going to have time for your child?
Sir, I don't know. I was unaware that it was this rocky, but she likes to paint quite the picture. So I guess I'm a little taken off guard. I mean, we don't even communicate a whole lot to the point where, I even know her opinion or stances on some of the things. So, she just abruptly asked me where I'm living, and I just happen to be moving in between homes, or, just the way it's kind of been going in Michigan lately.
So what's your parenting time supposed to be?
Right now, it's pretty minimal. It's it's been for the while there. It was actually just every weekend, and I could stop by her mom's because she drops him off at her mom's, and I usually would just stop by and just hang out with him there for a little bit because he doesn't like to leave, or he's very attached, which is fine. I usually try to just hang out with him and spend a little time with him.
So you want him to drop off the child to her mom's when?
I mean, if she wants to do supervised visits, I really don't even know how that's going to work. She doesn't like me at all. With all due respect, we don't necessarily get along. She likes to be very aggressive, and I'm almost threatened every other time just for, trying to surprise my son and say, "Hey, how's it going, buddy?" And it's like, "What are you doing? Why didn't you tell me before you get?" I just wanted to say hi. I didn't think it was a big deal. And I don't know, she claims to call the cops, and it's like, I don't even know what I do to the extent for her to be like that, but that's fine. If she wants to watch me hang out with my son, that'd be fine. I don't know why she'd want to, or she'd want someone to. That wouldn't be a good experience for anybody. But again, he'll grow up one day. He'll figure it out.
And does your mom be willing to watch?
I'm sorry?
I'm sorry?
Is your mom willing to have him come over for a couple hours?
Yeah, my son gets out of school and she's the one who helps me pick him up from school. So that's why he was going to my parents' house to see him there. And then the reason that he was talking about surprising him is he went to the school to try to take him out of school. And it was the school that actually called the cops because he wasn't supposed to be there.
Call the police. He didn't call the police. They said literally a lot of wow, man, that's unreal.
His ID, and they found out he's an offender, and they told him he couldn't be there. So they were the ones that called the cops. It wasn't me. And then the second time that he went, he was already told by the principal that he couldn't go to the school. And he still went again to try to take out our son. Even though I
wasn't told by anybody. I was actually told that I had to bring a birth certificate and proof that I have some sort of custody with agreement from the court, and that I could have took him out of school. That's what I was told by that same secretary. She said, as long as you have your birth certificate, I have. So
you had no reason to take him out. That's the thing. It was during the day. It was time.
It was like 30 minutes before the school was about to close. It wasn't like a whole day.
He's telling me that he's broken his cell phone. I have 15 different phone numbers that he has called me from because he's breaking his cell phone. I have no way of knowing where he's at. I have no way of knowing where my son.
My cell phone just happened.
His visit.
My cell phone literally would drop into a ditch. That's unreal. What does my cell phone have anything to do with anything? I have another one right away.
All right. You can see your son at the grandmother's house for 2 hours every Saturday from 10 o'clock till noon. All right, until further order of the court. Ma'am, you got to make sure your son is there every Saturday.
I'll ask you what the basis for all that.
Okay,
what exactly is your
attending-
judgment in and making it that drastic. It's like I was actually sticking to a schedule that was better for her, and now I'm being punished for it.
Because I don't know anything about where you're living, where you're gonna be, how you're dealing with this. I don't know anything about it, and you just simply don't give me any information. So for right now, it will be at her mother's house from 10 till noon every Saturday. Thank you. You can come back and file something if you think it should be expanded.
Okay, that's fine.
Everybody, thank you. We're adjourned.
Okay.
This is a motion made by the defendant mother, said that the daughter is 18, is a senior in high school, and wants the child support to go until May. Any objection to that, sir?
I object, yes.
Based on what?
Based on 10 years ago when we filed the divorce, the agreements were put into the divorce. The terms were read aloud by the judge. We both had the opportunity to object to these terms. Neither of us objected. And the divorce documents were signed off on. And now I'm asking the court to honor those terms.
There's a uniform child support order that was modified in 2019. It calls for, as in every case, that child support shall continue until the age of 18 or graduate from high school, whichever is later. And it also includes that it cannot go beyond 19 and a half years old. Ma'am, is the child living with you?
She is living with me full time, yes.
All right, and is expected to graduate by before she turns 19 and a half, I'm assuming.
Yes, she will graduate in May.
All right, having heard your objection, I'm going to overrule your objection, sir. Child support shall continue until the end of May of 2024. That's what the law calls for, and that's what I'll agree to. Good luck, everybody.
The terms of our divorce don't mean anything.
Terms of your divorce, what? There's also child support can be modified at any time. It was modified in 2019. Did you object that it was modified then?
No, I let it go.
Well, and in that judgment, it just says, an event child has reached 18 or graduated from high school, post-majority. It allows for post-majority. It did say that the child we're dealing with, it would go to 8/31/23, because that's when she was going to, I assume, the friend of the court decided that that's when she would probably be done with school and she would turn 18. She did not turn 18 in that amount of time. And it says, if you read right above it, it cannot be extended beyond 19 and a half. The following children will be attending high school on a full-time basis after turning 18 years of age. She's turned 18 years of age and she has not completed high school. So it calls for extension of it until no later than 19 and a half. And this one she'll be finished before she's 19. So it will be extended to May of 2024. That's the ruling of the court. The motion. Good luck, everybody. Present by Zoom. It's the motion made
Thank
by
you.
the plaintiff mother. According to her, there was an order, back a temporary order, I assume, that ordered Mr. Snyder to be out of the house within 30 days. Move out of the marital home within 30 days of, looks like August 11. And still not out. Is that true, sir?
Yes.
Were you ordered out within 30 days by the judge?
I was 30 days and then it was 30 days and I had time to look for a place. If there was, what I assume we were supposed to have another hearing where to look to see if I had found anything. He wanted to see what results I had.
I don't think the judge said you were going to come back in 30 days and see what results you had. He ordered you out in 30 days. He gave you 30 days to move out.
Yeah. Yep. And he said if you're not out, he said something about receipts. So I'm okay with leaving like she's asking for right now.
Be out by Monday.
Is that 5 days from now? Yeah.
That's out by Monday. You should have been out before then.
Okay. I understand.
Ma'am, if he's not out by Monday, come down and get a personal protection order from Judge Hillary because he's harassing you and stuff like that. All right?
Okay. Thank you.
Monday. That means Monday. By 5 o'clock Monday, you're out.
Okay.
And if there are problems between now and Monday, you can come down and ask the court for relief, ma'am. And it's not going to go good for you, sir. You were supposed to be out a long time ago. and you're just dragging your feet. Sorry. It's the court order. I didn't make it, but I'm going to enforce it.
I understand.
Good luck. Have a good weekend, both of you. He will be out by Monday at 5 o'clock, or else come on down to the court. Okay, man?
Okay, thank you.
Good luck, everybody. Thank you.
Thanks.
Ms. Peterman?
Yes,
All right. Did you give him notice of this motion?
I did the motion and the remotion notice. So I mailed them both to his home.
And the motion and stuff was like more than a week ago and stuff like that?
Oh, yeah, it was, yes.
Is that a flag up behind you
August.
that says go blue?
Yeah, yes, it is.
You're taking a chance because I could be a Spartan fan.
I know. I had to plug it into the charger and it's in my husband's man cave. So
Well, you're lucky because I'm a go blue kind of guy. Matter Peterman versus Kwiatkowski. This is the plaintiff mother's motion for child support. She is requesting that child support be extended through next May because the child has turned 18 but is a senior in high school. Does she live with you?
yes, he does.
And she's expected to graduate next May?
Yes, he is.
All right. I'll grant your request. Child support shall continue until May of next year. All right?
All right. Thank you.
Go blue.
Thank you.
Good luck. Thank you.
Thank you.